Good morning to everyone. You've just heard the bell ringing, so it's our signal that it's the time to start. I hope everybody's fine. It is not the case, unfortunately, of Mr. Vazani, who's not feeling well today, now slightly unwell, he said. In normal times, this would be no problem, right? He would just sit there. Now we want to be cautious because we don't want to take any risks. So he's going to take a test in the course of the morning. If the test is negative, he will be here in the afternoon. If the test is positive, then we have to take it from there. But for this morning, the suggestion is that he connects on Zoom. He's already connected. And if the parties want to make sure that he's there all the time, you could connect into Zoom and just see that he's there. Does that work? And of course, if he has questions for witnesses, we will show him on the Zoom screen. Is that acceptable? It's a little unfortunate, but these are the types of things that can happen, and it's good that we have the Zoom set up so we can continue. Is it fine with the claimants?
Yes, it is, Madam President.
Thank you. Is it fine with the respondents as well?
Yes, no problem.
Good, fine. Anything else in terms of organization that we need to address before we start? Doesn't seem to be the case on either side. Yes, I'm checking the transcript. It is running. Good morning, Mr. Makicevic. So I'm told that the interpreters are here, and I also see them, and I welcome them. They will not interpret for now, but they will interpret, I think, for the last witness this afternoon. Fine. Mr. Markicevic, to you now. You're Igor Markicevic?
Yes.
You're an advisor to the Rand family since 2012, is that right?
Correct.
You have provided us with 4 written statements, 5th of February 2018, 16th January 2019, 3rd October 2019, and 5th March 2020.
Yes.
And you have them all there, I
Yes,
see.
yeah.
Absolutely. You heard as a witness, you have been here with us before, so you know that I will now ask you to read the witness declaration, please.
I solemnly declare upon my honor and conscience that I shall speak the truth, the whole truth, and nothing but the truth.
Thank you. So I'll first turn to Claimant's counsel.
Thank you, Madam President. Good morning, Mr. Markicevic.
Good morning.
Did you have a chance to review your witness statements recently?
Yes.
Is there anything you would like to change?
No.
Could you please tell the tribunal what happened in Belgrade yesterday?
Yes. Yesterday, around 11:30 a.m. in Belgrade, the police showed up in front of my door, in my apartment. And since I'm away, my father, who is 71 years old, he's spending a few days in the apartment, and he opened the door. Police told him that they're looking for a Canadian citizen named Mr. Aaron Broško. And my father said that he didn't know who Aaron Broško was, and then police said that they had Mr. Broško registered on that address, and my father said he didn't know anything about that. And then they took my father's, they wrote down my father's name and the data from his ID card, and then they left. They didn't leave him with any notice or any document or explained why they came.
Fine. Well, we'll take note of this.
Thank you.
you.
Mr. Markicevic, could you describe other encounters you had with Serbian law enforcement in connection with BD Agro?
Yes, the contacts, as I explained in details in my written statement, contacts with Serbian police started in June 2019, when police officers showed up in office in Belgrade where I work, and I was not in the office at the moment, and they talked to my colleague who was there, and they asked for my mobile number. Then they called me and insisted that I meet them in the police station. We had several meetings at which they requested certain documents of Crveni Signal, but they didn't want to be specific about which documents they're requesting. We had some back and forth communication. I engaged a Serbian criminal lawyer to advise me in that matter. He advised me that I should always have a written notice and request from the police with respect to documents. They even threatened me that they will file criminal charges against me for obstruction of justice because I'm not giving them what they are verbally requesting for me. At the end of the day, we had a meeting with lawyers and police, and they gave in writing their request for the documents. I provided the documents immediately after that. On all our meetings, they always raised questions, issues on the matters that are discussed in these arbitrations. So they asked about who was the owner of BD Agro, who bought BD Agro, how it was funded, etc. So it's various matters discussed here. And I have to say that before this arbitration started, I was never even charged with a parking ticket. So all my experience in life with police is during this arbitration.
Mr. Markicevic, what was your understanding of the ownership of BD Agro at the time when you were at the company?
My understanding was always that Mr. Obradović is a nominal owner, and that Mr. Rand and his children are beneficial owners through SAMBI investments.
Mr. Markicevic, are you a director of SAMBI?
Yes, I am.
Mr. Markicevic, are SAMBI's financial statements audited?
Yes, financial statements of SAMBI are audited every year.
Mr. Markicevic, do you know whether SAMBI's financial statements for the year ending 31st December 2008 were also audited?
This was before my time, but I reviewed. I have in possession copies of most of SAMBI's documentation, so I reviewed the 2008 financial reports, and they are audited, yes.
Sir, we will now distribute one document to you. It's document CE 420. The printed copy is shortened. We wanted to save some trees.
Yes.
Thank you.
Sir, is this document the financial statements of SAMBI for 2008?
Yes.
Could you please tell the tribunal the date of the audit report?
The audit report is dated 10th of December 2009 by HLB.
Do you know, sir, when SAMBI changed its registered office to the current address?
SAMBI has a decision on change of the office dated 1st of November 2009, but Cypriot administration, they registered in the corporate register, official corporate register in April 2010. But decision was from 1st November 2009.
Mr. Markicevic, does Mr. Obradović owe SAMBI approximately 2.7 million euros?
Yes.
Did he confirm this in writing in 2019?
Yes, I was involved in accountants from Cyprus prepared the financial reports, but I was reviewing them and they were audited, and auditors requested a written statement of outstanding amounts with all creditors and debtors, including Mr. Obradovic, who signed a statement that he owes this amount to Serbia.
Mr. Markicevic, is it your understanding that BD Agro would have become profitable if the pre-pack reorganization plan had been pursued in 2015 and the following years?
Yes, this is based on the business plan that was very carefully made by people who were involved in BD Agro and outside consultants. And I have to say also that majority of creditors supported it, but I don't mean only majority in terms of volume of their receivables, but also it's 53 or 54 companies from agricultural business who were BD Agro's creditors who voted for the plan. So these were all BD Agro suppliers, buyers of raw milk, producers of different chemicals, seed, and inputs for crops production, for dairy farm. These were companies that BD Agro dealt with on daily basis for years, and I think that they knew very well what was BD Agro's potential, and they reviewed our plan, and they believed obviously in it because they voted in favor of the plan. I also have to say that I noticed on the opening statement, Serbia's opening statement on Monday, comparison with past results and profitability of the farm, and I have to say as economist that this is, from my point of view, it's incomparable, because the biggest point, the whole reason for having a large industrial scale dairy farm is economy of scale. And BD Agro never in the past passed the threshold of maybe 25–30% of capacity utilization. And the pre-pack business plan envisaged investment and increased the size of the herd and capacity utilization, which was 90 or 100%. So that's where economy of scale hits, and I don't think it's even possible to assess future potential of the company based on past results to say BD Agro had perfect setup, equipment, facilities to operate as industrial size, but they didn't have enough cows. So that was the whole idea. So this is why I'm certain that pre-pack would be successful and that BD Agro would be a very profitable company.
Mr. Markicevic, were you ever told by the privatization agency that resolving the privatization agency's allegations of breach of the privatization agreement was as simple as to make Crveni Signal in INEX return certain amounts to BD Agro?
No. The first time that I heard this theory that the only thing that we needed to do is to have Crveni Signal and INEX return the loans was this Monday on Serbia's opening statement. So to state the obvious, if I wish that was the case, because then in that case it would be easy for Mr. Rand, even without engaging any funds, to settle that matter, because Mr. Rand was owed by BD Agro over 2 million euros at the time. So it would have been easy for him to assume, for example, Crveni Signals and INEX debt, and to settle that with his own receivable against BD Agro. But that was not the case. The privatization agency, in all their notices, all our meetings, they always claimed various breaches, including 533, 521, and a list of another 5 or 6 additional breaches, which sometimes we found hard to understand what was the request that they were making.
Thank you. That concludes my direct examination.
Thank you. Can I now turn to Serbia's counsel, Mihai?
Yes, of course. Thank you, Madam President. Good morning, Mr. Markicevic. My name
morning.
is Senka Mihaj. I'm one of the counsels for the respondent. And I will ask you a few questions today. Speaking of criminal proceedings, would you please tell us how many criminal proceedings have been opened against you until today?
Against me, I'm aware of one, if I remember correctly. Yes.
One. Do you know how many criminal charges were filed against you?
I know that BD Agro and management that was appointed after I left filed several baseless criminal charges against me, but I never, police or anyone ever followed up with me on that.
And were there any criminal charges filed against you before this arbitration started in relation to BD Agro?
Not that I know of, no.
You are not aware of a criminal charge filed in 2014 and in 2016 that relates to BD Agro?
No.
Can we please see? We do not have it in the bundle because we didn't know that this will show up, but we will, of course, have it in records. Then these are exhibits RE 260 and 669. So my point is only to show that there is a criminal charge against you filed in November 2015 and 14. And
It is a complaint, right?
Yeah.
It's not a charge, technically. It's a complaint filed.
well, can we see the Serbian version, please? Yeah, it says, it is a krivična prijava, which means, and we have translators here. So krivična prijava on Serbian means criminal charge.
That's
Yeah,
not correct.
To me, a charge just is someone files a complaint, there is an investigation
Yeah,
by
that's
the
right.
relevant authorities, and the relevant authorities consider that there is sufficient ground to proceed, and they file a charge, and
Yes,
then
you are correct.
goes to
Yes,
court.
you are correct. Criminal complaint.
So it's a
that's-
complaint, yes, good, thank you.
And can we go to another exhibit?
Can I just ask, because I saw something in the document, if I'm allowed to just...
Of
comment?
course.
If you can scroll down to the end of the document.
Sorry, English or Serbian?
Anyone, because I noticed that it was not signed at all. So it says workers left to thieves, but so this, I never seen this before, and this seems to be unsigned, anonymous document. Just wanted to point out.
I think that it says somewhere that it is received by the prosecutor. Yeah. Admission seal, so we have that it is received. And can we go now to RE 669? And that is also criminal complaint from 2016 against Mr. Markicevic that relates to BD Agro. In 2016. And tell me, these criminal complaints, criminal charges that are filed against you, do they all relate to BD Agro?
Madam
or
President,
not?
I must object.
Yes.
We have seen two criminal complaints, and I think you have explained to Mrs. Mihaj that the proper English term for these documents is criminal complaints. She should not be referring to criminal charges.
Oh, sorry, I didn't,
But I'm-
I didn't pay attention, and I heard, I
I see.
didn't hear charge.
And
but
complaint.
I think we agree that the first one is an anonymous complaint that was received by whatever the authority is. And here we see one that is not anonymous because there is a name below, and that is also a complaint and was also received. Do I understand this correctly, Mr. Merkic?
I also, so just a quick scroll through the document, I don't have it in front of me, but I noticed that it is signed by the general manager of BD Agro, after I left BD Agro, as I said earlier.
Yes, thank you. And you
It's a
were
complaint.
aware of these complaints?
No. I was never contacted by Serbian authorities about these complaints.
Thank you. Ms. Mechai, you may continue.
Thank you. So are there any other criminal complaints against you that do not relate to BDR?
There is one, yes, as I mentioned, there is one, and the only one where I was contacted by Serbian authorities.
Would you please tell us something about that complaint? What was it related to?
Yes. So it is a complaint at Crveni Signal. It's another company owned by Mr. Rand in Belgrade. Crveni Signal has a backyard, and in that backyard there's a gate that is used by Crveni Signal and several other residents which use the same backyard. And Crveni Signal, we installed a ramp which controls who gets in and out, because we had problems, people who don't live there, they used our backyard. And one of the neighbors who lives in the same backyard is a truck driver, and he has a truck, a big one with a container, 20-feet container. And one morning he broke the gate and parked his truck in the middle of the backyard. And I talked to the other neighbors if they saw anything, how it happened, etc. And one of the neighbors told me that he saw the truck driver broke the gate. And then I talked to a lawyer who represented Crveni Signal at the time, and the lawyer advised me to file criminal charges and compensation of damages for the gate.
Criminal complaint.
Yes, because that was the basis to
No,
get...
no, not a criminal
complaint.
charge. You were filing a criminal complaint.
Not that uncommon place in Serbia to file criminal complaints against people. The lawyer who wrote a criminal complaint then turned sides and defended the truck driver against Crveni Signal. The neighbor who told me that he saw the driver breaking the gate, he changed his testimony in front of the court. We have security cameras recording where the truck driver was chasing the witness with a metal bar around the yard, and we filed this with the police, which I believe was the reason why he changed his testimony. In any event, Crveni Signal lost that case against the neighbor, and then neighbor and the lawyer who wrote the criminal charge against the neighbor wrote criminal charges against me for false testimony. So that's the only criminal proceeding against me ongoing in Serbia. And I was invited once by the public prosecutor. I gave my statement on that and provided video footage and other documents with respect to that. And that's...
Thank you.
Thank you. Thank you, Mr. Merkicevic. Mr. Merkicevic, you are a director at Koropi since 2013, is that correct?
Yes.
And you are also director at Serbia since 2013, is that correct?
Yes.
And you are also director at Claimant Investment from Cyprus, is that correct?
Yes.
And since when you are a director at Claimant Cyprus?
Claimant Cyprus, also June, I think, 2013.
And you are also director at Claimant Investment from Serbia, is that correct?
I'm currently as director of Claimant Serbia since, I think, 2018. I don't remember exactly the date.
Thank you. And you are also director at Crveni Signal from Belgrade.
Yes.
Since when?
Since September, I think, 2012.
And are you also director at company Obnova from Belgrade?
Yes.
From
also
when?
Around September 2012.
Mr. Merkicevic, would you please tell us, was your average monthly income last year about 250 euros?
Objection.
Excuse me, can you repeat the question?
Objection, Madam Chairman, Madam President.
Yes, I was checking the question. The question was, can you tell us your monthly average income last year? And then what was the figure?
My question was your average monthly income last year about 250 euros? That was the question.
250?
Yeah.
Yeah, okay. Is this a question you, I understand there is an objection. Is this a question you wish to answer or not?
I don't mind answering.
I
don't mind answering.
You don't mind? Is there a
Madam
reason for
President.
the objection?
Well, Madam President, I think maybe if Ms. Mihai could explain the relevance, then perhaps we could assess the objection.
Yes.
What's the objection?
Why is the relevance of the question?
Well, Madam President, Mr. Markicevic just confirmed that he is director at several companies that, according to claimants, all relates to Mr. Rand. And as we saw during testimonies that we heard yesterday, it is a big question how much associates of Mr. Rand and whether received any compensation, what was the amount of that compensation, etc. And we think that that could be of relevance for the stories, for the claimants claiming these proceedings and the truthful of their claims. So we would like to see whether Mr. Markicevic know what are his incomes and what is the amount of his incomes. As you may remember, for example, Mr. Obradovic was unable to tell the exact amount. So I hope Mr. Markicevic could tell us.
Yes. You want to reply to this?
I simply want to say that I maintain the objection, and unlike the compensation of Mr. Obradovic, the compensation of Mr. Markicevic was never an issue in this arbitration at the written stage.
Yes.
And if I can add, I said that on the second thought, I realized that this is streamed, as I understand, or will be publicly, video. So I'm not very comfortable talking about this publicly because people, seeing this later, my personal income. If you want me to answer, I would answer, but I'd rather not. So that would be my.
Yes, I am not. Do my colleagues have specific questions to the parties to better understand the question and the objection?
Yes, perhaps we could hear Ms. Mihai, because I tend to agree with Claimant's Counsel that there was relevance with regard to Mr. Obradovic's compensation in terms of nominal owner and beneficial owner. I don't quite yet see how that's same relevant to Mr. Markicevic, but and I apologize, Ms. Mihai, if perhaps just one more time on the connection.
First of all, I think that it is also relevance for the credibility of the witness, but as well for the credibility of claimant's story in this case. So they are saying that this witness manages several companies of Mr. Rand, and that he actually runs a lot of his...
Being a director, to me, is not the same thing like being a manager, right? A director sits on a board, maybe a non-executive director, and has a few meetings a year. So it's a different, we should not mix this, right?
But I tend to agree with you, but having in mind the evidence that we have in the files, and of course also the witness statements of Mr. Markicevic, I would say that he did manage these companies, that he was acquainted with their businesses and was general manager. And I don't know, I think that the question of his compensation should not be a problem to be in the files. I fully agree that we can exclude that part from the transcripts and the video that would be published. Of course, I have no problem with that. But I think that it would be fair that we finally hear the amount paid to Mr. Rand's associates, who are all involved in all of these privatizations, not only BD Agro, but other companies that are mentioned by claimants themselves.
maybe the tribunal needs to rule then on the subjection. Maybe we just go to the breakout room, and we make sure that we establish from there the connection to the Zoom. Is this possible? You take your computer, yes, fine, good. Thanks for waiting. I just have to check one thing in the record, so if you still bear with us. So it's PO5.
Yes, I have it.
Oh, you have it, good. Good. Thank you all for waiting. And we have set a special breakout room with Mr. Vasrani to make sure that we can deliberate. We would say the following. Mr. Markicevic, you can choose to answer or not to answer this question. We will, if you decide to answer, we will treat this as confidential. We have an order, transparency confidentiality, which is procedural order number 5, and that specifically provides that during a hearing, information can be treated as confidential. That means that we will the tribunal will decide whether to exclude the information in question from the broadcast, so that we would exclude it from the broadcast, and whether the relevant portion of the transcript shall be marked confidential. That is also what we would do. And so what will be published will not contain this information, and we will also advise Canada that is not online now, but that can access the transcript later on during the day, that there are portions that are confidential. Is this an acceptable way forward?
Yes,
Mr.
Madam
Becker?
President, it
Thank
is.
you.
Yes, absolutely, thank you.
Fine, and Mr. Markicevic, now it's up to you to tell us whether you want to answer or not.
Thank you, Madam President. I would say that I can confirm that I employed in Cerveni, I have employment agreement with Cerveni Signal, but I'd rather not answer on the amounts of my salary, if that is okay with the tribunal.
So you have an employment agreement with
Only
Cerveni
with
Signal?
Cerveni Signal, yes.
And you have no other agreements in terms of employment, or
With other companies mentioned, I don't
with
have.
the other companies, you have remuneration from the other companies as
No.
director, for instance?
I don't.
No. And your advisor role is compensated by this Cerveni Signal employment agreement?
I have a company that I own called Avento. I am co-owner with my wife in that company, and that company invoices Mr. Rand for my services. So I'd
For
rather,
services?
yes. So I'd rather not mention the amount if that's acceptable for the tribunal, but that's the company that charges for services.
Thank you. I think that answers it as much as it can be answered.
Yes. Thank you, Mr. Markicevic. I would now like that we go to your fourth witness statement, and that is para 31. Can we see what you said in this paragraph? So I will tell my understanding, and then you can read the paragraph and correct me if I'm wrong. So you said that Kalemegdan Cyprus is direct majority owner of Inex Crveni Signal, PIK Pešter and Obnova. You also said that the nominal owner of Kalemegdan Cyprus is Mr. Obradović, and that Mr. Rand advised you that the beneficial owner of Kalemegdan Cyprus is Koropi, because it can obtain transfer of shares in Kalemegdan Cyprus from Mr. Obradović at the time of its choosing. And finally, you said that Koropi is therefore beneficial owner of Inex Crveni Signal, PIK Pešter and Obnova. Is that a correct understanding of what you said?
Yes.
So since you confirmed that you are director of Koropi, has Mr. Rand ever provided you with an agreement that establishes such beneficial ownership of the company that you manage?
Yes.
So you have been provided with a written agreement of Koropi's beneficial ownership over the company that you mentioned in para 31 of your fourth witness statement.
Yes.
Thank you. Tell me, Mr. Markicevic, since Koropi is, according to you, beneficial owner of Inex Crveni Signal, PIK Pešter and Obnova, has Koropi registered its beneficial ownership in its financial statements?
I would only have to rely on my memory. I would say probably yes, but I would have to check with the financial statements because I'm not able to maybe give exact answer on the spot. But
Mr.
I believe so, yes.
Mr. Markicevic, aren't you a person who signs those financial statements since you are a director of Koropi?
Yes, but as I said, I don't have in front of me, and I'm not. My answer is yes, most probably yes, but I would have to check with the financial statements to confirm that. The financial statements are prepared by the accountants in Cyprus, and they are also audited, as well as Zambia's financial statements. So I believe yes, they reflect the ownership.
Okay, thank you. And you have mentioned that decision about the registered address of Zambi, or to be precise, the change of registered address of Zambi was rendered sometime in November, if I remember, 2009. Would you please tell us who renders decision of change of the address of Zambi?
Directors of Zambi.
But do we agree that in any event the registered office of Zambi at the time when you say 2008 financial statements of Zambi was prepared were still not the address that is registered in April 2010?
So financial reports, to my understanding, were filed in December 2009. So this was after the change of the seat, after the decision on change of the seat. So this is why in this period between the decision and the registration in the corporate registry, to say they state the different addresses, but I believe that the accountants and auditors in Cyprus took the position that change of ownership is as of date of the decision.
Change of ownership.
Oh, sorry, change of address.
So this is what you know or what you believe?
Well, this is what the documents say. So the decision is as of 1st November, and the financial reports are filed in December, and they state the address which was in the new address from the decision from November 2009.
Well, as I know, we do not have that decision on change of Sambi's address from the November 2009.
Well, as I said earlier, I'm in possession of a copy of that decision, and I understand it was not raised before here, so I would be happy to provide it to tribunal if needed, but I was not asked by the council to provide it because it was not discussed until this moment.
And do you maybe remember when this decision on change of address was filed to the relevant company's register?
This was, as I said, this was before I was engaged. So I have a copy of the decision, but I don't know the details when it was filed. So I see that the date in the corporate registry is April 2010, and the date on the decision is 1st November 2009, but I don't know when and how it was filed. I was not there at the time.
Thank you, Mr. Markicevic. Mr. Markicevic, in your witness statements, you testify about a great number of meetings and interactions with the privatization agency, the Ministry of Economy, regarding BD Agro. Did you maybe keep any record or minutes of these meetings?
I had some notes in my notebook, but not minutes in a sense of the proper minutes from the meetings.
You haven't provided any of these notes together with your witness statements?
No, these were just written notes in my notebook, which were my reminder of what was said at the time.
And Mr. Markicevic, during the 2 years that your request for assignment of the privatization agreement from Mr. Obradović to Koropi was active before the privatization agency, have you ever visited the website of the privatization agency and consulted the applicable rule book that prescribe the conditions for assignment of the privatization agreements?
No, I believe that what the agency told us was what was required for the assignment was sufficient. I didn't find it necessary to go to their website and be informed there, because we had meetings and the correspondence with the agency, and I took that this is their position.
And if I remember correctly, you said that that you received the list of the documents from the agency.
Yes.
And you stated that the list stated that you have to submit official certificates from competent national authorities confirming that no criminal proceedings were pending and that no previous convictions exist against the controlling shareholder of the company to which the agreement should be assigned. Is that correct?
Can you?
Yes, of course.
Refer
Witness
me
statement.
to
Yeah, can we see witness statement, third witness statement of Mr. Markicevic, paragraph 24. I'm sorry, 94.
Thank you. I see it, yes.
But you never provided these official certificates, just a simple personal statement from Mr. Jennings that he has no pending criminal proceedings nor convictions. Is that correct?
This is correct, but this was a very common practice with the privatization agency, and the reason is that if you look at paragraph 93 above, that the request was specifically to provide so that has never been convicted of criminal offenses, including those listed in Article 12 of the law, privatization law, etc. So in practice, and I've done some privatizations before I met Mr. Rand and got involved in BD Agro, that foreign countries would never issue a certificate referring to Article 12 of Serbian law of privatization. So that was a general problem with foreign investors providing such a certificate, and it was common practice, and I would say probably 100% practice with the privatization agency to sign, notarize, and apostille affidavits from foreign persons that they comply with this requirement. And this is what was provided to the agency.
Yeah, but the problem with this statement that you gave is that you never mentioned the particular privatization agreement that was transferred in the way you said, without showing official certificate concerning criminal proceedings and convictions.
I'm not sure I understand the question.
You never pointed to a particular privatization agreement that was assigned without official certificate concerning criminal proceedings or convictions. You just said that it is practice of the agency.
Yes.
As
correct.
I'm aware, it is not the practice of the agency. So I would expect that if you said that in your witness statement, you also mentioned to which privatization agreement you refer when you said it was a practice. But you didn't do that.
I
have
did
you?
not provide, yes, as
Yes,
you say,
okay,
in my
thank
witness
you.
statement,
Yeah, thank you.
what you say.
In your second witness statement, you also testified about the reorganization of BD Agro, and that would be somewhere from para 188, for example. And I think that it would be convenient that we remind the tribunal and ourselves about what you said in that respect in your witness statement. So in para 188, you say that on 13 September 2015, the Commercial Court of Appeal quashed the court approval of the pre-PAC reorganization plan and returned the case of the first instance court to the first instance court to repeat the procedure. And then in third witness statement, in paragraph 112, you say that on 22nd October 2015, BD Agro received a notice from the first instance court ordering it to act in accordance with the orders from the decision of the Commercial Appellate Court, and that the deadline set by the court was 15 days. And you further say in para 120 and 121 that on 26 October 2015 you sent a letter to the privatization agency explaining that the commercial court had ordered BD Agro to act in accordance with the instruction from the Commercial Appellate Court and set a 15 days deadline. And finally, you conclude that the privatization agency never responded to your letter, so that 15 days deadline for BD Agro's compliance with the court order expired, which was the reason for the first instance court to reject the amended pre-PAC reorganization plan. So, in the letter from 26 October 2015, and that is CE 360, you requested, that would be, I think, the last paragraph, instructions from the agency in that respect. Is that correct?
Just give me a moment, please. Where is the Serbian original?
Behind.
Yeah, I see.
It's here.
Okay, but can you please repeat the question, because you went through 2 witness statements in one document and I lost track of it.
I just wanted you to confirm that in this letter, from 26 October 2015, you requested instructions from the agency.
Yes.
Yes. And tell me, please, have you contacted the agency after you sent this letter on 26 October? Did you urge that they respond to your letter? We saw no documents in that regard in the files.
No.
Thank you. And have you maybe requested from the court to postpone the 15-day deadline left by the court?
Soon after this date, the agency appointed privatization trustee, Ms. Knežević. So my communication was with her, and she was on daily basis in the agency. So I told her, and she had a copy of this letter, and I informed her, and I believed that the agency was informed through her about what was going on with the pre-pack reorganization plan and our deadlines with the court. I was urging her to talk to the agency to get a response, but we never got back from them.
And until when you were director of BD Agro? What was the date when you left?
I resigned in November 2015. I think it was 5th November.
So you were still the director at the time in October. Is that correct?
Yes,
Yes.
after I resigned,
So
I was director for another 30 days, which was legal requirement to the
Okay,
minimum
so
notice.
So I repeat my question. You was a director. You was aware of the 15-day deadline.
Yes.
You have sent the letter to the agency. The agency did not respond. You are still a director. And my question is whether you addressed the court to request the postponement of 15-day deadline, or you did not.
I don't remember if we asked court for additional deadline.
I'm sorry.
I don't remember if we wrote to court for the additional deadline.
Okay. Can we go to witness statement, so the second witness statement, paragraph 192. And you will see in that paragraph, you actually confirm that it was not a problem to ask the court for an extension of this time limit and receive such extension. So I think that this statement of yours shows that you was aware that it was possible to request delay of that deadline, as well as that you did not do that.
I don't see that it says that I did not do that. It says that that would not resolve the problem that the agency didn't respond to the request. And
It says that it would have been resolved by simply asking for an extension of this time limit.
so
But, okay.
So
whatever you say.
the paragraph says about but for scenario in which we got if the pre-pack, when the pre-pack first instance decision was quashed, if we got a chance to do it again, and I can speak if you allow about the reasons, how I understand the reasons why it was quashed. It was, say, technicalities that we were able to overcome. And what I'm saying here in this paragraph is that if we were in position to proceed and to continue pursuing the pre-pack reorganization plan, that we would be able to get additional deadline from the court, that we would be able to make new financial statements, which was required in the court's decision. So to move the cutoff date for the pre-pack reorganization plan forward, to make some amendments to the plan, to acquire a new auditor report, etc. So I'm saying that that would be possible to do, and that my expectation was, because the creditors already supported the pre-pack plan, that I don't have any reason to think that they would not have done it again, because nothing changed in the meantime. And what I'm saying here that I believe we would be able to have been able to get from the court additional deadline to do all these required changes and to put the plan again in front of the creditors and the court for voting. So this is not with respect to my request to the agency to get instruction from them. This part of my witness statement speaks about why I believe that the pre-pack, if the termination didn't happen and if we remained on the same course, that the pre-pack would be approved again.
And in your third witness statement in para 111, you say that on 1st October you received notice from the privatization agency that the privatization agreement had been terminated. So having in mind that the privatization was terminated, well, is it correct to assume that you were actually no longer interested in BD Agros organization and that this was the reason why you stayed passive and did not urge the agency to respond, did not request the 15-day deadline to be extended? Is that maybe the reason?
No, that is not the reason.
Thank you. Can we please go back to your fourth witness statement? In para 32, you say that on 23rd January 2019, Kalemegdan Serbia registered Mr. Obradović as the real owner. And I suppose that you approved or signed or co-signed this request for registration of Mr. Obradović as the real owner.
No. This was
You
before.
didn't?
No. So the registration was done before I was appointed as director of Kalemegdan. So this is before my appointment. Previous director and more specifically accountant made this registration, and when this was brought to my attention, so I reviewed the article of the law, which is in my paragraph 34 of my witness statement. My understanding was that both Mr. Obradović and Mr. Rand should be registered.
We will come on that question later, but please let us now stay here. Did you co-sign, signed, or approved? And you said no, and I have the follow-up question.
The registration was before I was appointed as director of Kalemegdan.
Thank you. And could we please go now to Exhibit CE805? And that is the company's register decision which registered you as the director of Serbian Kalemegdan Investment in 1st July 2019. And it says that you see to be deleted. So it means that you were already the statutory representative of Serbian Kalemegdan Investment, and that the previous director, Lidija Cebović-Milenković, could have represented the company only with your co-signature. Is that correct?
Correct.
So it seems that Ms. Milenković could not file any registration without your co-signature approval.
Registration was done by, as I said, by the accountant. So registration is done on the website of the Business Registers Agency. So they have application where the accountant put the name in the section for the beneficial ownership. At that time, Ms. Cebović-Milenković was director, and she didn't. So her limitation of power to say was to sign documents, to sign contracts, to sign bank transfer orders, etc. So she needed my signature for that. But this was something that is done online on the website of the Business Registers Agency, and they didn't. Both accountant and Ms. Cebović-Milenković didn't consult with me on the registration.
But is it correct that this registration, which is filed electronically, as you said, that, as I know, it is correct, it is true, but it is also true that it should be signed by electronic signature.
Yes, and it can only be and only signed by the electronic signature of director of the company.
Who is limited with your co-signature.
Yes, so only electronic signature by director of the company, which is a question which we often deal with the business registers agency, because I cannot, for example, authorize accountant to file anything so I always have to go as a director, so no one else, even if you have several directors, there is one who is authorized, and his ID card with electronic signature has to be used. So this had to be Ms. Cebović-Milenković's electronic signature.
But you also was the representative of the company, and you did not need any co-signature.
With the business
Representation
registers,
sole, it says for you.
yes, as I said, with the business registers agency on their website, all applications can be done only with the director's electronic signature. No authorized representatives, no lawyers with power of attorney, no accounting or audit firms. It has to be only the director's electronic signature. This is often a logistical issue. For example, when you have a foreigner who is a director of Serbian company, you have to bring them to Serbia physically to bring their electronic signature to sign documents. So this is often a nightmare. This is why I know that this is exactly and the only way it can work for any registration.
Mr. Markicevic, are you saying that powers of representation of Ms. Milenković was limited by your co-signature, except when the registration of the real owner is in question?
I don't know if that's the only case, but with respect to registration on the website of the Business Registers Agency, it could only have been director's electronic signature. And I'm sure this can be checked.
Mr. Markicevic, do
Business
you know
Registers
that?
Agency easily.
Mr. Markicevic, do you know that concealing the actual owner of a company is a criminal offense according to Article 13 of the law on Central Registry of Real Owners? Are you aware of that?
I'm not a lawyer. I don't know the articles of that law, but I believe this registration was not incorrect. This is what I tried to explain earlier when I was interrupted, but I don't know if I can.
Yes, you can.
Yeah, so I understand that this article, which regulates the obligation to register the beneficial owner, would include both, basically, both Mr. Obradović and Mr. Rand, because the Article 3.1 says, just give me a second, please. Individual which directly or indirectly holds 25% or more shares, stake, voting rights or other rights based on which he or she participates in managing, etc. So Mr. Obradović held directly 25%. And 3.2 says individual who directly or indirectly holds prevailing influence on business activities and decision-making process. So I believe that Mr. Rand would fall under this decision. So my understanding was when I analyzed from my ability, I'm not a lawyer, of this matter, was that both Mr. Rand and Mr. Obradović should be registered. But this is not possible technically on the website of the Business Registers Agency. It's impossible to register more than one person. So it can be two persons who share ownership, like 50-50 or something, but you can't register two in chain of ownership, multiple persons who fall under these definitions. And then I sent a letter to the Ministry of Economy and letter to Business Registers Agency and asked for clarification, since they're logistically and technically it was not possible to do what the regulation requires us to do. And I got response that which I interpreted that Mr. Rand should be registered, and that's when I basically deleted Mr. Obradović's name and registered Mr. Rand's name.
Mr. Markicevic, was Lydia Milenković aware that Mr. Rand is beneficial owner of Serbian Kalemegdan Investments?
I believe that she was, but this is, I believe, would be a question for her. I believe she was aware of it.
So actually you are saying that Ms. Lidija Milenković committed a criminal offense by concealing the actual owner of a company?
No, I'm not saying that.
Let us go back to para 35 of your fourth witness statement that you just mentioned.
Sorry, paragraph?
34, I'm sorry.
Mhm.
And you quote Article 3.1 of Law on Real Owners. And you said that Kalemegdan Serbia had to register Mr. Obradović in 35, in paragraph 35 you say that Kalemegdan Serbia had to register Mr. Obradović under Article 331 simply because of his nominal ownership of Kalemegdan Cyprus. Is that correct?
Yes, that was my understanding.
So, but according to the provision that you quote of the law on central registry of real owners, so it says that beneficial owners of the registered subject shall be individual which directly or indirectly holds 25% or more share, stake, voting rights or other rights, based on which he/she participate in managing of the registered subject and or participates in the capital of registered subject with 25% or more shares. So according to this provision, the real owner is individual who directly or indirectly holds 25 or more shares. One, based on which he participates in managing of registered subject, or two, based on which he participates in the capital of the registered subject with 25 or more shares. So, having in mind the options from this article, and these are two options, I don't understand why did you register Mr. Obradović as the real owner? Did, according to your opinion, based on his indirect holding of shares, participate in managing of Kalemegdan Serbia, or did Mr. Obradović, based on his indirect holding of shares, participate in the capital of Kalemegdan Serbia? So did he participate in managing or in capital of Kalemegdan Serbia? And when I say he, I mean Mr. Obradović.
Mr. Obradović does not and did not, since I was involved, participate in managing Kalemegdan. And as I explained in my witness statement, my understanding, I'm not a lawyer, so I cannot, this is, I think, now going into a legal discussion, but my understanding of this article is that, the fact that he is nominal and registered as a nominal owner of Kalemegdan Cyprus, this falls under this 331 definition. So in this first part related to the holding 25 or more shares, 25% or more shares. So my understanding was that. But again, you asked if I registered. I didn't register Mr. Obradović. So just to point out once again that he was registered before I was appointed, and then I made a change in registration after I was appointed, and after I reviewed this and had correspondence with the Business Registers Agency and the Ministry to clarify the issue.
But before you did register Mr. Rand as the real owner, you tried to register both Mr. Obradović and Mr. Rand as the real owners of 200% of shares.
Yes.
Is
so
that correct?
that is correct, and it was not possible in the application.
Well, is
that
it possible at all that two-person holds beneficial ownership over 100% of shares?
I believe also this is a legal question, but
Yeah.
if tribunal wants me
No,
to.
I think you've explained what you did, and it is indeed a legal question, so we can leave it there.
And just to be clear, you try to register both Mr. Obradović and Mr. Rand as the beneficial owners only after respondents pointed out in its rejoinder that Mr. Obradović is the registered beneficial owner of Kalemegdan Serbia. Is that correct?
Correct, because the previous registration honestly skipped my attention until that point. I was not even aware of it.
Thank you, Mr. Markišević. Can we go back to second witness statement? And in paragraph 143, you say that in March 2015, Mr. Stajic, and that is BD Agro's temporary bankruptcy trustee at the time, and Mr. Kostic informed you that the privatization agency had sent a letter to the Ministry of Economy stating that according to the privatization agency, the privatization of BD Agro had been finalized because the purchase price was paid and the obligatory investments were made. So in files, we have plenty of documents sent by the privatization agency to the ministry as well, but none of them is stating what are you saying here. Did you maybe try to get a copy of that letter from the gentleman that you mentioned in this statement?
Yes, so I would point out that Mr. Stajic, who was a temporary bankruptcy trustee at the time in BD Agro, his brother was a board member of the privatization agency. And I got this information from him. I asked him if he can acquire a copy of that letter, but I did not get it from him. So I've never seen the copy of that, so this is why I stated here that this is what was told to me by Mr. Stajic, but also by Mr. Kostic through different persons, the chairman of the agency. So I got the same information from two different sides, and I believed it was what happened, but I can't confirm that the letter actually exists.
In your second witness statement, you also speak about alleged unlawful termination of the privatization agreement, and that is paragraph 167. And in that paragraph, you quote a part of the agency decision from June 2015. You go down? Yeah. Ovo sve dolo znači. Yeah. Can you see that, please?
Yes, but I'm looking at hard copy.
Yes, of course, no
Give me a
problem.
second,
Take your
please.
time.
Okay.
So, as I understand, you contend that the pledge referred to in this quotation, can you go down, please, was subsequently deleted. Is that correct?
This is a quote from the auditor.
So this pledge is given, I quote, pledge is given as security for third-party liabilities have not been deleted. However, these obligations have been settled and conditions have been met to delete the pledge on this basis. And my understanding is that you claim that this pledge was deleted in September, I would say, 2015.
he's talking about various pledges. One was deleted on the date when, around the date, I believe,
Well-
what you said, but there were other pledges that remained, but the underlying loans were settled long before that, and the auditor found that, as he said, obligations have been settled and conditions have been met to delete the pledge on this basis. And the only reason why the pledges still existed is because Nova Agrobanka, who was a government-controlled bank at the time, would not issue. So for deletion of the pledge in the cadaster requires notice from the creditor that the debt has been settled and that they agree with the deletion of the pledge, and Nova Agrobanka refused to issue such notice, even though the loan was settled long time ago.
Yes, I understand. And actually, you wrote this, that this quotation is from your letter that you sent to the agency in July 2015. And then we have the exhibits. I will show you, of course. You have sent to the agency, and that is exhibit CE 357. The decision of the we do not have it in bundle, but we of course have it on files. C357, you have delivered to the agency the decision of the Geodetic Authority Office from 7 September 2015, and enclosed. Can we now go to C87? And that is the document that was enclosed to this letter that we just saw. And that is decision of the Republic Geodetic Authority. Is that correct? And
What is the question? If this is decision of the Public Geodetic
Yes.
Authority? Yes, this
that
is
you
the decision.
delivered to the agency in September 2015.
Yes.
And you have delivered this document to show that the pledge was deleted. And you are referring to the pledge that we just saw that you mentioned in your witness statement. Is my understanding correct?
When you're referring to my witness statement, this is a quote from,
Yes,
from the auditor report.
Yes, of course.
So, just to
So
point
the
out,
auditor said, I fully agree with you, the auditor said that the pledges given as security for third-party liabilities have not been deleted. However, these obligations have been settled and conditions have been met to delete the pledge on this basis. And then you said in paras 168, in fact, the only reason why these pledges had not been already deleted was that we were still waiting for confirmation from the creditor Nova Agrobanka necessary for deletion of the pledges. And eventually, that confirmation arrived, and you addressed the cadaster, and you got the decision that we see as C87. I'm just checking if my understanding is
yes,
correct.
and
Thank you.
this is decision on deletion on one of the pledges. So there were various pledges, and as auditor noted, pledges giving as security for third-party liabilities have not been deleted, however, so it's plural. However,
Yes,
these...
but these are also decisions.
Sorry.
I'm sorry.
However, these obligations have been settled and conditions have been met to delete the pledge on this basis. So the auditor's report is dated, I believe, somewhere around January 2015, so before this deletion. So at the time, the auditor concluded that he referred to all the pledges that were allegedly problematic for privatization agency, and he said the pledges are there, but deletion, but the conditions are met for deletion.
Yes.
In the meanwhile, Agrobanka issues this one deletion notice, but for the 221 million dinars or 2.2 million euros loan, Agrobanka never issued the deletion notice to allow us to delete the pledge.
So can we go back to CE87 and see what pledge was deleted? So we can see from this document that what was deleted is the pledge that was registered on the pledge statement, verified on 7 June, 7 June 2010. And then it says, for the purposes of securing claims of the creditor towards crveni signal. On the basis of the agreement from 2 June 2010 in the amount of 65 million dinars. So this is the pledge that was erased.
Correct.
And can we now see what pledge secured 221 million loan that BD Agro took from Agrobanka and then gave the part of it to Crveni Signal and Inex, and that is RE9. So that is decision from 14 January 2011, and this is decision of the court
Serbia first.
reached according to the pledge statement of 28 December 2010. And then next para at the end, in order to secure monetary claim of creditor towards the debtor under the agreement on short-term loan of 22nd December 2010 in the amount of 221 million dinars. And as we can see from RE 45, this pledge was still in place in 2019. So the pledge that secured the 221 million loan given by Agrobanka to BD Agro, from which BD Agro loaned some money to Inex in Crveni Signal, was never deleted. Can we say that based on the documents that we saw? You can say that. You can agree with me.
I
Yeah.
didn't understand that was the question. I thought it was your comment. Yes, that's what the document says. As of
Thank you.
March 2019.
And do you know, have Crveni Signal and Inex returned the money to BD Agro, the money that they received from BD Agro, and that was loaned from BD Agro by Agrobanka?
Partially, yes. So when I was appointed in BD Agro in 2013, it was already, so it happened before that, Inex returned, so it was 30 million dinars loan, and Inex returned, I believe, 12 million dinars out of that amount, and Crveni Signal's loan was 70 million dinars. Crveni Signal, also before I was appointed in BD Agro, returned, I believe, 5 million dinars or so, and also recently, in 2018, Crveni Signal repaid BD Agro's loan to Agrobanka in amount of around 200,000 euros. So, and this is what we got recently from the bankruptcy trustee of BD Agro, that he is setting off that amount to 200,000 euros with BD Agro's receivable from Crveni Signal. So I noticed, I think it is important to point out on the opening statement of Serbia of Monday that the amounts mentioned there are incorrect, because they are starting amounts, initial amounts of initial loans, and it was said that this was never repaid, so I would disagree with that. So I roughly, depends on the exchange rate, how we translate it from dinars to euros, it's about half of that amount that was stated in the opening statement. Considering this latest change. Just to explain, Crveni signal guaranteed for BD Agro's loan from 2012 of 9.5 million euros. And in 2018, Crveni signal paid to Agrobanka based on that, a guarantee around 200,000 euros. And then it had receivable based on that towards BD Agro. And we got, I think, a few weeks ago, a notice from the BD Agro bankruptcy trust.
Madam President, excuse me, here.
Yes.
I must ask if Mr. Markicevic is answering any particular question now.
No, but it's interesting to the tribunal to get
I see, thank you.
his information.
And
Do I understand correctly that what you state in conclusion is that 50% of the loans have been repaid?
Roughly, depending on the
and
exchange
50%
rate.
are still outstanding, and that's rough because...
Very rough, depending on exchange rate over years. And I apologize, but I understood that the question was if Crveni signal index ever repaid those loans, and I believe that this is the answer
thank
that
you.
was.
And if I understand, the answer is no. They haven't. They still
The
owe.
answer is yes, the loans were partially repaid. I believe that's.
And do you know what are the exact amounts owed to BD Agro at this day?
As I said, roughly around 400,000 euros, depending on exchange rate, owed by Crveni signal, and around 150, 160,000 euros owed by Inex to BD Agro.
MDH Serbia was in the ownership of Mr. Rand, is that correct?
Excuse me, can you repeat that?
MDH Serbia
Mhm.
was in the ownership of Mr. Rand, is that correct?
Correct, and still is.
And also, MDH holded minority shares in BD Agro, is that correct?
Correct.
And Mr. Markicevic, have you ever represented MDH at the shareholder meetings of BD Agro?
Yes, I believe it was once at the beginning, end of 2012 or beginning of 2013.
And were you director of MDH at that time or not?
No.
Thank you. Madam President, my colleague, Professor Đundić, will ask a few questions now, if that is okay.
Just a short one, if this is
Yes, it's
possible.
okay. We have not discussed whether there could be two cross-examiners for the same
I think that
witness,
it's
but
fine.
I don't see a difficulty. Is there a difficulty on the claimant's side?
No, we do not have a difficulty with a few questions being asked.
Thank you.
No, only one. Mr. Markicevic, I'm sorry that I have to speak to you this way. You're not seeing me right now. You explained that, roughly speaking, Crveni signal returned around 200,000 euros to BD Agro, but that was in 2018, right?
Crveni signal paid to Agrobanka for BD Agro's debt in 2018, and this year, a few weeks ago, we received a notice. So the Crveni signal reported this receivable in BD Agro's bankruptcy procedure, and we received a notice a few weeks ago from the bankruptcy trustee of BD Agro that his intention or decision, I don't remember exactly the document, is to set off these two amounts, and the remaining amount owed by Crveni signal is in euros around 400,000.
Yes, so this was almost 3 years after the termination of the privatization agreement and 3 years after you have left BD Agro, right? This set-off that you're speaking about.
I left BD Agro, so it's
Yeah,
5-6 years.
Okay.
Yeah.
Thank you. That's all, Madam President. Thank you.
Madam President, we have no further question. Thank you, Mr. Markicevic.
Thank you. Questions in redirect?
I have only one topic. Mr. Markicevic, you were asked a few questions about your actions with respect to the pre-PEG reorganization plan after the termination of the privatization agreement. Do you recall that?
Yes.
And you were shown a letter where you were seeking instructions from the privatization agency. Do you recall that?
Yes.
Can you please tell the tribunal why you were seeking instructions from the privatization agency?
Yes. So I was at the time that the privatization agreement was terminated, and I was aware of the article of a relevant law which said that I'm limited in making decisions, certain decisions, after the termination of the privatization agreement, that I cannot do certain things without approval from the privatization agency, and these included actions in pre-PEC procedures, bankruptcy procedures, and I believe that pre-PEC reorganization plan had measures envisaged in the plan which were grasped by these limitations from the law, and my understanding was that I was not allowed to proceed pursuing this adoption of the pre-PEC because it would, once adopted, become a binding document for the company, and I was not in position to proceed with that without approval from the agency. And also there was one maybe even more significant matter, because after the termination of the privatization agreement, Mr. Rand was no longer willing to provide financing for the most important part of the pre-PEC reorganization plan, which was his investment in increase of the size of the herd. And so I could have not possibly proceed with pursuing the pre-PEC in front of the creditors and the courts saying that there will be investment, while there was no actually expected investment at that moment. So I would not proceed with that in any event, especially having in mind that I already resigned, so I'm in this termination notice, and to pursue a document which would be binding for the company for the next 10 years, I just thought it would be very problematic if I pursued with that.
Thank you. No further questions.
Thank you. Do my colleagues have questions? Can we make sure that we show Mr. Vasani on the screen? Good.
Thank you, Madam President. I have just a couple of short questions, Mr. Markicevic. Looking at your first witness statement at paragraph 10, it says there that you and Mr. Broshko frequently discussed performance, and we were concerned that its level of milk production was too low. What other issues had you, or did you identify at the time? Because it couldn't only be that milk production was too low.
I can point out several major issues which were addressed in the pre-PEC reorganization plan. So as you mentioned, first one was the low level of production, which we addressed, for example, and as illustration, when we engaged a professional dairy farm manager. We managed just through change in diet and protocols on the farm, average production within 1 year went up 70% or more, and we were really amazed how that was achieved in such a short time. But also there is a issue of 40 million euros or so of debt, which was mostly with banks, and interest rates were not very favorable for BD Agro, so that needed to be addressed, which we did through the pre-PEC reorganization plan. There was also issue which was ongoing for a long time in BD Agro, and this is that BD Agro had way more employees than that was required for this kind of operation. And this was also addressed in the reorganization plan. As illustration, we had over 2 million euros in salaries and contributions and taxes, while farm like that with 100 employees or less would probably not need more than to spend more than 1 million euros or 800,000, what was in the plan for employee costs. So these were three major issues. There were some other as well that were addressed in the pre-PAC reorganization plan.
Thank you. As I understand, the price of milk is the single biggest driver of revenue and therefore profit. First of all, do you agree with that?
Well, price of milk, but also prices of the inputs used in the agricultural production. But most importantly, as I mentioned at the beginning of my testimony, was economy of scale, which is the whole point of having a farm of this size, because once you get to that point that you have high level of capacity utilization, then profitability is significantly higher than as opposed to small farms with 50 or few hundred cows. How
sensitive was your reorganization plan to milk prices?
We took a very conservative approach with all assumptions. So with milk prices, so we made sure that all prices, our outputs and inputs were we had buffers to say to not to be too sensitive to changes. Like our prices that we charged in reality to the milk buyers were higher than what we projected in the pre-PAC reorganization plan. We did the same with the input prices of the seed, chemicals, feed for the animals. So we always took a conservative approach and made sure that there is a buffer that would not make us vulnerable to changes in the market.
Thank you. Madam President, those are my questions.
Yes, please.
Thank you, Madam President. Good morning, Mr. Markicevic. I have two very, very general questions. The first one is, how do you evaluate the financial management of BD Agro before your arrival at the company?
Well, as I just said in my previous answer, so the fact that BD Agro had around 40 million euros of debt, and that most of it was towards the banks, and the interest rates were not very favorable for BD Agro. It could have been managed, I would say, in a better way, but everything, all consequences of management, I would say, are reflected in the level of liabilities. So that's obvious from the financial statements.
Thank you. So may I ask you, why do you believe that the privatization agency acted in the manner it acted?
That's a very hard question, and I would rather not speculate, if you allow me, but I don't know. We at all times, until the last moment, until we received the notice of termination, which was really a shock to all of us, all times we believed that the privatization agency will accept our arguments that the obligations from the privatization agreement were fulfilled, and we believe that the auditor's reports and everything that we showed them will be acceptable for them as proof that everything was in accordance with the agreement. And I also would like to point out that I called them personally to come to the farm, to give them office, to give them sandwiches and drinks, and to stay there as long as they need to to come to the conclusions and that we are transparent, but they never wanted to accept that invitation.
Thank you. No further questions, Madam President.
Thank you. Mr. Markicevic. You say in various places, especially your witness statement 2, paragraph 187, that the termination came as a utter shock. Maybe we can show this.
Excuse me, is it the second witness statement?
It's the second, yes.
Mhm. 87.
Do you read it? And I was asking myself, why was this a shock? Because there had been a number of notices that warned of the possibility of termination. Now, I read, of course, what comes before this, paragraph about the meetings, in particular with Mr. Kocic, who gave you some information that you considered positive, but still, I was a little surprised by the fact that you say this came as a shock. Was there not a whole evolution that seemed to be quite difficult, and the relationship with the agency was difficult?
Well, with enough experience with Serbian administration, so we were aware, of course, I was aware of these notices, but I always thought they were so baseless that this is the typical Serbian administration issue. Some bureaucrat just needs to make a decision and to move on. And all representations made to us by high-level officials from the ministry and the agency were that this is just, this is going to be fine. We apologize for the actions of the privatization agency and statements like that. So just from the reading of their requests and from the auditor's report and all the facts that were available to me and that we delivered to agency, I really believe that it's just a matter of bureaucratic reluctance to make a decision and move on. And I know that I believe that they will come to their senses and accept auditors' reports and all evidence that we provided to them to prove them that we are right.
Yes, but you also, at least in one letter, yeah, it's C46 of 2nd of July 2015. You seem to say that there is some non-fulfilled. We can show it, of course, so you're not. You know what I refer to. I think it's on the second page. Where it says somewhere the buyer fulfilled all contractual obligations as of the date of payment of the last installment of the purchase price, except in relation to lending to third parties, and then we mention Anex and Severus Signal.
Mm-hmm.
Well, was it therefore not? You admit that there's part of the obligations that are not met. So is it not reasonable or not unreasonable that the privatization agency insists on compliance?
So that language, it was scrolled down, but that language is, I was referring to what the auditor said in their report. So the agency in their notices made certain requests. We gave those requests to the auditor. This is, I believe, referring to Prva Revizija auditor report. And
But that is just, do I understand correctly, this is an audit that you provide to the agency?
Yes, I'm providing this to the agency and referring to, so I'm referring to auditor and Prva Revizija auditor reports, in which it is clearly and unequivocally stated that the buyer, so it's stated in their reports that the buyer fulfilled, et cetera, in relation. So everything after, so it's all referring to what the auditors say, and this is what the wording is from the Prva Revizija report. And we believe that the time that, so the auditor determined the facts, so the fact was, and it was not disputed that there were loans to Crveni Signal and Inex, so that there was that amount owed, but we thought the auditor is not legal expert, so we didn't refer to this as his legal conclusion. So we didn't dispute with the agency that there are outstanding loans, and the auditor certainly is not say in position to give legal, or the agency did not request for the auditor to give legal interpretation of those existing loans, but just to determine if they are there or not.
But then once you write this, why do you not say the auditor say this, but for legal reasons this is irrelevant or something like that?
I think we have now, there is a letter, I think, to the agency where we say the loans were never prohibited by the privatization regime.
Yeah, I would have to check this, yeah.
I believe maybe if I get a chance just to review the document, that it is the same letter.
Yeah, let's... Do you have a paper copy there, maybe, that you could, because that would be easier, so Mr. Markicevic can go through it and is not depending on someone else scrolling down.
Can I say that? It will be helpful for me.
I was expecting someone to give you a paper copy, but maybe this, we have no paper copies anymore. Yeah. I'm sorry about it. I didn't find it in this letter, right? But we can check the record.
It's either in that one or the one, I think, that was signed by Mr. Obradovic was sent to the agency. So in one of the letters in later stage in 2015, it says that there is no stipulation of privatization agreement, so I'm paraphrasing now, which prohibits loans to third parties. So that was said to the agency.
We'll check this, yeah. There are also explanations about the ombudsman intervention in your witness statements. And if I look, for instance, more specifically to witness statement number 2, page 37, paragraph 160, you say that you're shocked that the Ombudsman was publicly taking a very hostile position against BD Agro and clearly pushed for termination of the privatization agreement. When I read the recommendation of the Ombudsman, he doesn't say there is a need to terminate or there's a recommendation to terminate the privatization agreement. Why do you view it that way?
I think it's important to read the entire correspondence between the Ombudsman and the agency and the ministry. So he refers to them, they respond to him what they did, they gave us additional notice, and then he says that he's not satisfied with that. And then after they terminate the agreement, they report to him that they terminated the agreement, and then he says that this satisfies his recommendations. So I'm paraphrasing, but so it's important to see the entire correspondence between them.
Thank you. Still in your second witness statement, paragraph 17. You, you speak there about the fact that the privatization agency did not release the pledge over the shares of BD Agro, and you considered this to be merely an issue of administrative inefficiency, and it would be quickly resolved. On what basis did you think so?
As I said earlier, on some experience with Serbian administration. So sometimes it's, and this is early stage of my involvement. I reviewed the notices from the agency. I reviewed the auditor's reports at the time, which seemed to me that show that that everything is, say, covered and confirmed that it was okay what the privatization agency alleged. And I believe that this is, especially reading the pledge agreement, which was, I'm not a lawyer, but seemed pretty simple and clear to me. And I saw the confirmation from the agency that all installments were made, and pledge was still there. So that certainly seemed to me as some kind of bureaucratic
obstacle,
problem.
Or yeah. Your opinion changed later on? Because that was your early involvement.
Yeah, yes, my opinion didn't change, but all the time during our conversations and meetings with the agency, of course, we expected that they will, and we hoped that they will, in shortest possible time, accept the argument that everything was completed.
If I go to, I'm still in your witness statement, to paragraph 36, there you speak of the way you were looking to increase profitability, and one thing was cooperation with milk processing companies, because you want to increase the revenues from the sale of milk. You say that your efforts there, I mean, and you mentioned different companies with which you take up discussions, and then you say that your efforts were not successful, and you say all of the companies we approached were unwilling to enter into cooperation with BD Agro until transfer of the beneficially owned shares into the nominal ownership of Mr. Rand. I was asking, and then you speak of this Italian company, La Bovarina, that apparently seems to have the same type of concern. Why would these companies care about the structure of the ownership, who's beneficial, who's nominal owner?
So shares were registered on Mr. Obradovic's name. So Central Securities Depository, because BD Agro was a public company, shares are registered and publicly available information on the website. So and if when one looks at the website and sees Mr. Obradovic's name, there is red letters below and state the shares are pledged. And just to say basic due diligence, everyone who came to talk to us, we felt that it is fair to say that who is the beneficial owner, what is the situation. They see in the Central Securities Depository, when they see that the shares are pledged, they ask this question, and we would explain to them what the situation was, and that our expectation is that it will be resolved soon and to our benefit, but we couldn't give any guarantees for that. And you can see from the documents and from my witness statement, so we had discussions with them that went over a certain period of time with expectation that all that will be resolved. But for example, this La Bovarina, this is family company, so they were going to to basically move the entire factory from Italy to disassemble there and to move it to BD Agro and put their processing facilities in BD Agro. And they saw this as a risky
Kind of a red
situation,
flag.
red flag, something that, okay, we are negotiating, we are almost all details of the deal have been negotiated, but to execute it, to realize it, it was too
So it is more the
risky.
pledge of the shares that raise
Raised
concerns
flags, yes.
of possible issues of solvency.
Yes, and also most of them met Mr. Rand in person, and these are, especially when we mention La Bovarina, small family company, so it's their preference to have good personal relationship with the owner, and this seemed important to them.
Yeah, thank you. On paragraph 93 of your second witness statement, this appears in different other places and also with other witnesses. It's the account of this meeting on 15 December 2014, where you, Mr. Broshko, the lawyer, met with representatives of the Privatization Agency and the Ministry of Economy. And when you get there, Mr. Obradovic is already in the meeting room. Why was he there?
I believe it was by mistake. Someone
Whose
so
mistake?
we talked to after he left. We talked to people from the agency and the ministry who were there. So no one knew. Someone from the agency, I believe, called him, but I don't know exactly who. And when we came, Mr. Broshko explained, as I said in my witness statement, that there is no reason for Mr. Obradovic to be at the meeting because he doesn't represent Mr. Rand or BD Agro, and that we are discussing the transfer of ownership and the pledge. And they asked him to leave, and he left. But I cannot answer to a question who asked him, who invited him, because they never told us.
When you say that he has to leave, whatever the reason is, do they not say, but he's the owner?
No.
Why can the owner not, he's the
So
main shareholder, why can he not be here?
they did not ask him. So Mr. Broshko explained to Ms. Galic, who was assistant to Mr. Stevanovic, who is a state secretary, and so we were in the hallway in front of the room, meeting room, and he explained to her, repeated again who is beneficial owner, and that Mr. Obradovic has no business doing there, and they didn't complain. She went to Mr. Stevanovic, and they asked Mr. Obradovic to leave, and he left. So no, there was no discussion about it.
Then you mention in paragraph 104 of the same second witness statement, you speak of another meeting with the Privatization Agency and the Ministry. I think it's the one on 16 January 2015, as can be seen from paragraph 101. And there you mentioned that one of the representatives of the Privatization Agency stated that BD Agro should indeed be forced into bankruptcy, and you were shocked. It's actually the third time that you are shocked in this witness statement. Can you explain this? Was this part of the discussion? Does this come out of the blue? What were the reactions? What did other representatives say? What did you say? What did you think?
The discussion was about transfer of ownership or pledge, and also about pre-pack. So we were explaining them, so we were under pressing schedule to say in front of the court, and trying to get to their decision to proceed with the pre-pack. And in the middle of discussion, so we were offering solutions. They were coming back with unreasonable requests back, and then I think it was Mr. Doklestic, the lawyer. He said, "So you are saying no to everything that we propose. So what is your proposal? How do we deal with this?" And then she said it should go to bankruptcy, and We said, is it really possible that we have pre-pack, we have 50 companies lined up to vote for the pre-pack, and company can survive, Mr. Rand wants to invest money in BD Agro, and you say that you want to push it to bankruptcy. And this is when I commented, I said, you will have, because it was very often that in front of privatization agency, they had protests of the workers from the privatized companies. And this is where I said, do we want another few hundred people in front of the building? And she said, that's not a big deal for us. We have that every day.
What was her role at the privatization agency?
She was at most of the meetings, but I don't remember exactly what's
her title
What's her
was.
title? Yes, she was. Ms. Julijana Vučković was the most active, to say, speaking to us, but Ms. Kostić was on most of the meetings present.
Did you think this was her personal opinion? This was the expression of the agency, of the view of the agency? How did you understand this?
No one from the agency said that they agree or disagree with this. So we were at that point in discussion with her, but it's not that they said that they all stand by this point that it should go to bankruptcy. So I cannot say if she was saying this in her personal capacity, but she was there representing privatization agency.
Was Mrs. Vukovic in this meeting? She's
would-
not listed, at least, in your... Well, you don't identify the representatives. You may not remember. Yeah.
Yeah, but I don't remember, but she was on most of the meetings, so it's.
Yeah. Let me see what there are still questions that I have not asked. No, I think I covered what I needed to ask. So if there are no other follow-up questions from anyone, is there one?
Yeah, Madam President, this is, if you recall, there was discussion about the letter where BD Agro, let's say, disputed the legal obligations under 534.
That's the
that was in
letter of
response to your-
2nd of July.
Yeah, and Mr.
2000.
Markicevic said that maybe it was stated in another letter.
Yes.
So could we please show to Mr. Markicevic document CE 48 corrected? Yeah.
48.
Yeah.
I see the cursor on 8, so it's 48. It's not in this
Oh,
bundle.
they don't have the corrected. Then can we take over the screen, so to say? Oh, you have it, yeah. Okay. So, could you please show the first page?
So this is a letter of 10 September 2015, yeah?
Yes, and then if you could scroll down to page 3. It's towards the middle of the page. In addition, starts the paragraph. Yeah. And actually even the preceding paragraphs. Well, but most importantly, the one which is highlighted now. Is that what you had in mind, Mr. Markicevic?
Yes, I was referring to this.
Thank you. no further questions. Is there, yes?
Madam President, just one short question. To follow up on your question about the Ombudsman
Yes.
and its statement to the agency, the witness then said, well, there is correspondence between the Ombudsman and the agency, and then he interpreted this correspondence. Could the witness tell us when he learned or when he got familiar with this correspondence between the Ombudsman and the agency? Was it during the preparations of this case?
I believe it was during this arbitration. I can't
Thank
remember exactly.
Thank you. Good. So that leads us to the end of your examination. Thank you very much,
Thank
Mr.
you.
Markicevic. And this will be a good time to take a break, would it not? And then we go over to the examination of Mr. Broszko. Good. Let's take 15 minutes then. Let me ask Marcelo. It's not very kind if we just push him. It's not very nice to drive him.
More for like safety. Until we know. But yeah. Yes. Yes. Yeah. If we are
Maybe we should give him the choice. Yeah. Let me ask Marcelo.
Hello.
If we're on the record, we don't have sound.
Yeah, apologies. I was just saying good morning to Mr. Broshko. So you're, for the record, can you confirm you're Aaron Broshko?
I confirm.
You're the managing director of Rand Investments since 2012.
That is correct.
You have submitted 4 witness statements, 5th of February 2018, 16th January 2019, 3rd October 2019, and 5th March 2020.
That is correct.
Is that right?
Yes.
You're heard as a witness under, as a witness, you're under duty to tell us the truth. Can you please read the witness declaration?
I solemnly declare upon my honor and conscience that I shall speak the truth, the whole truth, and nothing but the truth.
Thank you. So I'll turn first to Claimant's Counsel for direct questions.
Thank you, Madam President. Good morning, Mr. Broshko.
Good morning.
Mr. Broshko, you submitted 4 witness statements in this arbitration. Have you had a chance to review them recently?
Yes, I have.
Is there anything you would like to change?
No.
Mr. Broshko, could you please tell the tribunal when and why you got involved with BD Agro?
In 2011, I had finished my tenure as Chief Executive Officer and then Executive Chairman of a publicly traded biotechnology company in Vancouver. I was considering what my next steps would be, and I was introduced to Mr. Rand through a lawyer who has relationships with both of us. We had talked through 2011 about different opportunities, principally resource opportunities. Nothing really tickled our fancy, and so in December of 2011, Bill and I had lunch, and he asked me, how'd you like to go to? I actually thought he said Siberia at the beginning, but he said, no, Serbia. And so we had a discussion about Serbia. He explained to me that he was the owner of a number of companies, that he bought them in the privatization process. One was the largest dairy farm in Europe, and he wanted to talk about how we could work together and potentially have me go down to Serbia to help with oversight of the companies. He explained the ownership. He says, I own them. I've got a local guy who helps with management. He's the, I don't know if he used the word nominal owner, but he said the shares are registered in his name, but I'm the ultimate owner. And he said that the ownership ran through Cyprus. And we had a good long conversation and follow-up conversations, and ultimately I agreed. And in February of 2012, I packed up my whole family, including our 3-year-old and 2-month-old at the time, and we moved to Belgrade, and we were there for 6 months.
Mr. Broshko, did you attend the opening statements on Monday?
Yes, I did.
Do you recall Serbia's counsel stating that the alleged breach of the privatization agreement would have been cured very simply by having Crveni Signal and Inex return certain amounts to BD Agro?
I did hear that.
Did the privatization agency or the Ministry of Economy ever advise you of this?
Never.
Thank you. I have no further questions.
Thank you. Ms. Mihai.
Thank you, Madam President. And good morning or good afternoon,
Good
Mr.
morning.
Broshko. My name is Senka Mihaj. I'm I'm counsel of the respondent, and I will ask you a few questions today. So let me start where my colleague stopped. Can we go please to RE 22? And that is the note from the meeting held in the premises of Ministry of Economy, and you will see that you also attended this meeting. It was held in December 2014. Can we now go, please, to second page of that document? And it was stated that the representative of the entity stated that the condition regarding the already stated audit finding had not been changed, and that, in their opinion, the biggest problems in executions of obligations of the buyer from the respective agreement on sale of capital were claims which the entity had towards the company Crveni Signal Beograd and Inex Nova Varoš. So I would say that the repayment of money by Crveni Signal and Inex to BD Agro was not only discussed, but was raised and acknowledged as the biggest problem in executions of obligations of the buyer. So would you please comment on that, because you were present at the meeting?
So the minutes of this meeting, I submit, do not accurately reflect what happened in that meeting. I would never have stated that the biggest problems in the execution of obligations of the buyer were the repayment of these loans. Logistically speaking, because there was no restriction on BD Agro in terms of making loans to third parties, I could have simply cured the issue even through my Serbian company by giving a loan to Inex and Crveni Signal, having them repay BD Agro, and then BD Agro just in turn reloaning the money back to Crveni Signal and then repaying my loans to Inex and Crveni Signal. So I would never have said that, and it's just simply not true.
And Mr. Broško, but it says that representatives of the entity stated, so maybe I think that Mr. Markicevic was also there. Yes, he was, so maybe he said that, for
No,
example.
he didn't.
It was not said that you stated
No,
that.
no, he didn't say that.
So are
No,
you saying?
okay, but if you may.
Yeah, of course, please.
Neither of us said this. Neither of us believed this. And certainly nobody had provided these minutes to us at the meeting or, to my recollection, after the meeting to allow us to comment on them, because if they had, we would have stated that we believed that this was certainly a misrepresentation of anything that was said.
Are you saying, Mr. Broško, that these notes from the meeting, that this document is then fabricated?
No, what I'm saying is that the text here, which says that the representative of the entity, I don't know if they're referring to me or to Mr. Markicevic, they're saying here that the biggest problems were the repayment of these debts. And what I'm saying is that is simply not true, because logistically, we could have addressed that very quickly.
And according to your recollection, so what have you considered as the conditions required by the agency for the privatization to be finalized, if this was not that? What problems you understood?
Sorry, are you asking what was told to us?
Yes.
So I would reference in particular the notices that were sent by the privatization agency to BD Agro, where they outlined continuously, at least until the moment of termination, that there was a breach of 533, there was a breach of 534. I think they even mentioned 521, which you may recall is in reference to the obligation to make the investment amount, which was made and accepted by the privatization agency years and years and years ago. So what we were seeing in those notices was, in particular, on 533, that there was a breach. I think it was outlined in the opening statement that the breach had only, it's not even a breach, that the disposal of assets went over the noted or prescribed threshold only because of the culling of the cows, which, as a lawyer, I would say is force majeure. It's a pretty clear case. So 533, we never believed there was a breach. We believed that it was a pretty straightforward case of force majeure, but it continuously was alleged by the privatization agency. With respect to 534, we also never believed that there was a breach. In fact, we believed that 534 had been complied with. And so we talked about, in particular, when they said about the loans, we never believed that there was any restrictions on the granting of loans. And we believed that the pledges that had remained with Agrobanca should have been, and they had an obligation to discharge when the loan was paid off in 2010.
So you did understood that there are some problems with completion of the privatization because there are some breaches of the privatization agreement. Was that your understanding back then?
No. What I noted earlier is we believe there were no breaches of the privatization agreement.
Okay.
And to the extent that there was any room, which we didn't believe, for reasonable or disagreement with reasonable people, the conditions under the privatization agreement were complied with the payment of the purchase price. But what we also know, simply by the record and the notices from the privatization agency, is that regardless of what we were saying, they continuously made these claims, which we believe were unfounded.
Thank you. Can we go now to CE 328? And that was the letter that you have signed. And on the third page of this document, this PDF document, point 3. So you said, the shares of BD Agro will continue to be pledged. I'm sorry, maybe I should read first the following. We suggest as follows. So this is your letter. And in point 3 you said, the shares of BD Agro will continue to be pledged in favor of the Republic of Serbia, and such pledge will be released only upon us satisfying within an agreed upon time period all conditions required to be met in order to successfully complete the privatization process for BD Agro. So from this, I understand that your understanding back then was that there are some conditions to be fulfilled in order for the privatization to be successfully completed.
That's not what we intended at all to convey in this letter. In fact, we had multiple meetings, 2014 into 2015. BD Agro, because of the actions, or perhaps lack of actions, taken by the privatization agency, was in a very precarious situation. We needed to get the pre-pack passed and adopted. We needed to put ourselves in a position where Mr. Rand could inject additional capital into BD Agro. And we were in a position here in January 2015 where if we didn't get that, if we didn't put ourselves in a position to have the pre-pack pass and capital injected, there was a very good chance that BD Agro would simply find itself in bankruptcy. And so what we wanted to do here is, because we had all these meetings, meeting after meeting after meeting, where we tried to find a solution, even though we believed there was no breach of the agreement, we found ourselves in a position where we thought, if we don't take a step back and look at practical and pragmatic opportunities here to put a pause in this, because we were having no success with the privatization agency, and no matter what we said, they did not want to listen to our explanations on these non-existent breaches. We took a step back and said, let's put it on hold. Let's try to see if we can just push these disagreements into the future and put BD Agro on solid footing through the pre-pack and a capital injection.
Mr. Broško, but I'm not sure that I understand your answer or that your answer was a answer to my question. You said in the letter CE 328 that you suggest that you met conditions required for successful completion of privatization process. So it must be that you knew what conditions were required to be met. Or otherwise, you would not say that in this letter.
I respectfully disagree.
Okay, thank you.
Do you mind if I just ask for a clarification while we have the document on the screen? So if I understand your answer, when you say, well, we'll leave the pledge until, and then you write all conditions required to be met in order to successfully complete the privatization process are met, or, yeah. So you write this as if the conditions were not met at the time of writing? Or do I miss something in the language?
That was never our intention, Madam President. As I noted, we were in a position where, even though time and time again we were explaining our position, we were explaining 533, and on 534 we were explaining that you're asking us, the privatization agency, to remove the pledge that they found problematic. And on the other hand, we had Agrobanka, who was controlled by the Serbian government, refusing to release them. We had made no progress with the privatization agency. We then were meeting with the Ministry of Economy as well. We were making no progress there. The time was clicking on was ticking on the clock to save this company. And what we thought is, rather than going back to them, a 10th time and saying, you're wrong in all this, let's just try to put a pause now. Even the pledge, for example, that we said the pledge would continue. The pledge agreement is a 2-page agreement, and it says right in there in black and white, when the purchase price was paid, the pledge gets removed. And we were losing on that, and they were refusing to release the pledge. So what we really wanted to do is have, at this point, no more disagreements with them. Let's just put this on pause, and let's do what we can so that we can get the pre-pack passed and adopted and allow Bill to put money in. That's all this was an attempt to do, because if we continued with our disagreement with them, we just felt we were going to continue butting heads and we would make no progress.
So if I follow you correctly, what this paragraph 3 says is basically we put our disagreements on the completion of the privatization process on hold for the time being, and we leave the pledge of the BD Agro shares, and we move forward with the assignment, which will
Yes.
allow us to get the creditor approval, which
Yes.
will allow us to have the
Yes.
reorganization plan approved,
Yes.
which will allow us to invest the money and reorganize the business.
That is correct,
Is that
Madam.
what
That
it
is
said?
absolutely
Yeah.
correct, Madam
Okay.
President.
Thank you.
And we honestly thought that eventually calmer heads or rational heads would prevail, and that we would come to an agreement and all this would pass. And because we were so unsuccessful in 2014 and the beginning of 2015, it led us to this position where we said, look, let's just try and throw them a bone so that they can allow us to take these interim measures, and let's deal with all this other stuff down the road.
Yeah, but of course you agree that this is implied, the idea that you park these issues and move forward and resolve them later. That is not written in the letter, or
That was our intent. I mean, we never intended to, number one, agree with them because we didn't agree with them. We never believed there was an outstanding breach at all. And again, because we were so unsuccessful in our dealings with the Privatization and Ministry of Economy, we had a decision to make. Do we try to move with interim measures to keep the company alive, or do we keep banging our heads against a wall, which almost guarantees its failure?
yeah. Thank you. It's clear. I apologize for the interruption.
Mr. Broško, would you please tell me, are you saying that you actually agreed to continue financing BD Agro even with the pledge? Had the agency accepted or approved to assign the privatization agreement to Koropi?
Well,
Is that what are you saying?
Well, that would ultimately have been Bill's decision, but I believe that had we shown some interim progress in getting the assignment completed and then putting the pre-pack in and allowing for the opportunity for Bill to finance the company, I believe he would have done that.
But you were the one who represented Mr. Rand at all these meetings to the agency, so I suppose that you must know what was the idea. So was the idea, okay, leave the pledge, we will continue financing if you assign the agreement to Koropi? I suppose that you can confirm that because you represented Mr. Rand.
Sorry, can you clarify what the question is?
Well, the question is, are you able to confirm, as the representative of Mr. Rand at that time, that the idea was that it would be acceptable for you that the pledge remains and that you continue financing in case the privatization agreement is transferred to Koropi?
It was never acceptable that the pledge remained. It was never acceptable that the pledge remained in clear contravention of the obligations of the government of Serbia. We never condoned that. We never accepted it. This was a very pragmatic attempt to try to save the company that had days, if perhaps a month. And so this was our attempt to try to put things on pause and to try to implement interim procedures.
Mr. Broško, I think that just seconds ago you said the opposite, that you said that according to your understanding, it was acceptable, the pledge to remain, and then you continue with the financing.
I think the problem was the word acceptable. You didn't really accept it,
We did
but
not
you
accept
were ready to do it.
That is correct.
Yeah.
You were ready to do it, okay.
We were never accepting of the fact that there was the pledge. This was a last-ditch effort, as I mentioned, to save the company. And we were trying to be very pragmatic in our attempt to allow ourselves to move forward for these interim measures.
Okay, so sorry for misunderstanding. Now I understand that you were ready to accept further financing, even with the pledge staying over the shares, in case the privatization agreement was assigned to Koropi. Is my understanding?
I'm sorry, if you could be clear in what the question is, I mean, I think I've just gone through a lot of this, but I'm happy to elaborate further.
Yes, of course. So I understood now that you said that you were ready to continue with financing of BD Agro in case privatization agreement was assigned to Koropi, and regardless of pledge staying over the shares, but that the condition was that the privatization agreement is transferred to Koropi.
I believe the bill would have done that, yes.
Thank you. Can we now go, please, to first witness statement of Mr. William Rand, and that is para 48. And here you will see Mr. Rand said, as the Serbian government was refusing to release the pledge on the privatized shares as they were required to do, I was getting increasingly concerned that the Serbian government would not live up to the terms of the privatization agreement, and I was not willing to make further investments into such an uncertain environment. So, the way I read it, it seems that Mr. Rand's testimony contradicts to what you have just said.
No, I don't think it does, actually. So what Bill had said throughout the entire time is what is stated in his witness statement, that there was a pledge that was inappropriately held, contrary to the terms of the pledge agreement that was committed to by the Serbian government, as we proceeded through 2014 and into 2015. And as things became increasingly dire, and there was a continued refusal by the privatization agency and the government to release the pledge, we found ourselves at the very end in a position where we either needed to do something to rectify the situation and get the pre-pack passed, or it was likely that all of this was over. And so we made a pragmatic decision, as outlined in that letter, to try to put things on pause to allow for that. The funding that was called for in the pre-pack was a funding over time. And so there was an opportunity, and I didn't draft the pre-pack, but I know the general principles, or at least many of them. But the idea was that there would be funding over time. So this was not necessarily a commitment right now of a significant sum of money. We could start this, we would be getting some satisfaction that there was an assignment. We would hopefully see some movement by the privatization agency to come to reasonable terms in an interpretation of the agreement. And then as we move forward with the pre-pack, there would be an opportunity subsequently to address again with the privatization agency and the Ministry of Economy, if necessary, the issues and the roadblocks that they had been putting up.
Thank you, Mr. Broško. And tell me, after you became involved in BD Agribusiness, have you learned what Mr. Obradović communicated with the agency concerning the breach of the privatization agreement? What was the position of Mr. Obradović in that regard? Have you consulted someone? Have you consulted the documents in that regard?
Would you be able to be a bit more specific in your question?
Have you consulted the documents that, for example, Mr. Obradović exchanged with the agency before you became involved in BD Agribusiness, the documents that concerned the breach of the privatization agreement?
Are you referring to the notices that the
To letters,
privatization?
for example, letters exchanged with the agency. Mr. Obradović, BD Agri's letters exchanged with the agency.
I have seen some of them. I wouldn't say that I know them in very significant detail, but I certainly have seen some of them, yes.
Thank you. Can we go to RE21? This is not a document from the bundle, but it is, of course, on the record, and we also saw this document yesterday. So this is a document that was signed by Mr. Đuro Obradović and Ljubiša Jovanović, and that is document from 2012. And you will see that in that document, Mr. Obradović informs the agency about the debt of Crveni Signal and the debt of Inex. And actually it says that the claim of BD Agro will be settled after the property of Crveni Signal is sold, as well as that Inex is selling a part of property out of which the obligation to BD Agro will be returned. So you will see in that document that actually in 2012, for example, that is the document for 2012, Mr. Obradović explains to the agency how it plans to settle the debt of Inex and Crveni Signal. And that is exactly the debt that was the reason for termination of the agreement. And then can we go back to RE22, that is the meeting that we saw, the notes that we saw a few minutes ago from 2015. And again, we have discussion about this letter, although you say that you do not remember that discussion.
I never said I
But-
don't remember that discussion. To be clear, I remember this discussion, and this was not said. But the prior document that you had referred me to, if you can put that back on the screen. I was in Belgrade. This is when I was first engaged. My involvement at that time period was not with this level of detail at all. I had arrived, I was giving consideration to general operational matters and trying to understand in terms of human resource issues where our strengths was, perhaps where some things could be improved. I was advised by Mr. Obradović at that time that there had been a dispute with the privatization agency. He had noted that he didn't believe there was any breach, and he noted that none of the conditions applied subsequent to the payment of the purchase price, which again was prior to my time. So I was advised this, but I was not involved at all in drafting this letter. And I've only seen it in the arbitration, so I can't comment on this letter, but I can definitely comment on the minutes you showed me. Those minutes are wrong. It was never said. I never believed it. And as I explained to you, the issue of those loans, if that was the only issue, which it wasn't, at least from the viewpoint of the privatization agency, if the only issue was the repayment of those loans by Crveni Signal Index, we would have been in a position to cause that to happen, and frankly, we would have avoided all of this. But that wasn't the case, and that's not what the privatization agency was certainly saying.
But were you aware that that was the issue? The only or one of many? But were you aware that this was the issue?
Was I aware that it was
Yes.
being, no, but was I aware that this was one thing that was being alleged among many by the privatization agency? Of course I was aware that this was one thing of many. But I was also aware that what also was being alleged by the privatization agency was that 533 was being alleged, which couldn't have been cured and wasn't a breach, and that in 534 that the pledges that they were asking to be removed were pledges that had no underlying loans, and by their very terms should have been discharged by Agrobanka, which was controlled by the Serbian government. So there was a whole bunch of things they were asking for. It was not, ever, just what you had noted in your introductory statement. It was never just pay back the loan. If that's all it was, and it was communicated to us, we would have just said, let's just get this over with, let's just deal with it, and we're done. Broshko.
No microphone from counsel.
Can we go
Thank
now
you.
to first witness statement of Mr. Broshko, paragraph 20? And you said that Mr. Rand had full control over BD Agro and that Mr. Obradović had no power in that regard. Is that correct?
Sorry, could you highlight what you're referring to?
I think I have the wrong reference here. Yeah. But of course I can ask you, is it your testimony that Mr. Rand had full control over BD Agro and that Mr. Obradović had no power in that regard? Is that what are you saying?
Sorry, can you repeat that?
Yes, of course. Is your testimony that Mr. Rand had full control over BD Agro and that Mr. Obradović had no power in that regard?
Mr. Rand had control over BD Agro, yes.
Full control over BD
I'm
Agro.
not sure, what is your definition of full control? I'm not, he controlled BD Agro.
I think either you have control or you don't have control.
it's-
If you have 51% subject to different voting rights, you have control.
I agree, Madam President.
Okay, I will continue.
No, but I think your question is, did Mr. Rand have control?
Yeah, of course, and he
Of-
confirmed that
of
that
BD Agro.
he did, yeah.
And the answer
Yes.
is yes.
Correct.
And do you say that Mr. Rand's control over BD Agro and his beneficial ownership were widely known among and accepted also by BD Agro's employees and business partners, customers, creditors?
You've piled a lot in there. Can you just repeat that question again, please?
Yes,
Maybe
no
more
problem.
specifically?
Are you saying that Mr. Rand's control over BD Agro and his beneficial ownership were widely known to employees, to business partners?
Well, I can only speak to my experience. I did not have interaction with the 200 employees of BD Agro, but what I can say is, with respect to my involvement as Mr. Rand's representative, that at all times, I certainly represented myself as his representative and Rand Investments. I represented that Mr. Rand was the beneficial owner. At all times, I represented that. And to my knowledge, any person that I had communication with, business partners and so forth, it was made known very clearly that fact, that Mr. Rand was the ultimate owner. So in my involvement, the people that I had worked with, I had, as a matter of course, stated this because I was saying who I worked for and what I was doing.
So practically nothing would effectively change with the transfer of the privatization agreement and shares from Mr. Obradović to Koropi or Mr. Rand. Is that correct?
I'm not sure I understand your question.
What would have changed with the transfer of privatization agreement and shares of BD Agro from Mr. Obradović to Mr. Rand?
Sorry, what would have changed?
Yeah, what would have changed?
Well,
What effectively would have
the
changed?
nominal ownership would have changed.
But why would nominal ownership would become that important after 8 or 9 years after the privatization took place?
Maybe you can be a bit more specific with that. I'm not.
Well, I think that it was a specific question. Why would the nominal ownership over shares in BD Agro became that important after 8 or 9 years after the privatization of BD Agro?
So the genesis of the request for the transfer of shares was that Mr. Obradović in 2013 was replaced by Mr. Markevich, that we had made certain changes within BD Agro, that along with that we had decided to replace or to hire individuals that had very specific knowledge with respect to large herd management and so forth, to more professionalize the individuals running what logistically was a complex organization. As part of that, Mr. Obradović ceased to represent Mr. Rand with respect to BD Agro. And so part and parcel of that transition was, of course, to transfer his nominal ownership from Mr. Obradovic to an entity that of Mr. Rand's choosing, and it ended up being Karopi. So the importance of this, number one, was that it should have been there should have been no issue with the request for the transfer of this. And as we went along continuously with the privatization agency, it continued to be a proxy for the belligerence of the privatization agency in refusing to accept a number of obvious things. Number one is that the pledge should have been removed, and there should have been no need at all for us to make this request and seek their approval.
Mr.
And
Brosso,
so-
I'm sorry, but we are far away from my question.
But that's what would have changed. That's
Why?
what would have changed. The nominal ownership would have changed. It
Yeah,
would have
but why
given.
was that important? I don't still understand what are you saying? What are you implying? I understand that the management changed and that Mr. Mrkicevic, in that regard, as you suggested, replaced Mr. Obradovic. But it wouldn't be strange that Mr. Obradovic remains the owner of the shares while Mr. Mrkicevic could manage BD Agro.
Yeah.
So why would the change of management require the change of the owner of the shares? This is my question.
They were both hand in hand. When Mr. Obradovic was, I would say, when Mr. Obradovic ceased to be involved in BD Agro, it was a wholesale change that Mr. Rand wanted to undertake, and that included the transfer of nominal ownership. And so when it was asked, it became of heightened sensitivity, again, because we believed throughout that the privatization agency and the government of Serbia were not complying with the terms of the privatization agreement. So
But-
to answer your question, it would have given us
But-
increased confidence. It would have given us increased confidence that perhaps the privatization agreement was starting to do the right thing and was starting to comply with reasonable requests that we were making, and we were seeing none of that.
Mr. Broško, I would like to refer you to the letter sent by Mr. Obratovic to the agency on 8 September 2015, that is Exhibit CE 48. And that is the letter containing a threat of initiating arbitration under the Canada-Serbian BAT. And in your third witness statement, you say that this letter was in fact just formally sent in Mr. Obradovic's name, but that it was drafted by you, Mr. Markicevic, and the attorney Slobodan Doklestic. He was Mr. Rand's legal counsel. Is that correct?
That is correct.
And you also say that Mr. Rand approved the letter. Is that correct?
I believe he did, yes. I don't know if he went through it in specific detail, but I believe he did approve it.
And you further state that would be paragraph 16 of your third witness statement. You say that when you wrote the paragraph referencing arbitration under the Canada-Serbian BAT, all of you were wrongfully under the impression that Mr. Obradovic would have the standing to bring a claim under the BAT. Is that correct?
Yes, we had gotten wrong advice.
Mr. Broško, you are saying that if dual nationals were allowed to initiate arbitration under the Canada-Serbian BAT, well, actually, this arbitration would now be called Obradovic versus Serbia instead of Rand versus Serbia. Is that what are you saying?
Well, you're asking me to speculate. I'm not an arbitration lawyer, so I don't know what would have happened under those circumstances. What I do know, which is what I put in my witness statement, is that we had been given advice from a local lawyer in Belgrade with respect to the treaty between Canada and Serbia, and it turned out very quickly that that advice was not accurate. Hence, this has not happened.
So your understanding that Mr. Obradović, as the national of Canada and Serbia, would have the standing to bring a claim under the Canada-Serbian BIT. That is what you said in para 16 of your third witness statement. Is that correct?
I can read what it's,
That's really a legal assessment.
But
The only thing that I understand Mr. Broshko is saying is that he thought that was the case at the time this letter was drafted.
I fully understand that this is legal understanding, and I'm not going to ask any question about whether it is correct or not, the legal understanding. But my question concerns what he said. He said, my understanding was that he is double national of Canada and Serbia, and that nevertheless he has the standing to sue. And then what happened? The letter, which was prepared by Mr. Broshko, was sent to Serbia, the notification. And my question was, so from the legal perspective, if that was acceptable, that Mr. Rand could sue as dual national of Canada and Serbia, that would mean that this arbitration would proceed as arbitration of Mr. Obradović against Serbia.
No, I
So-
understand your question, and I think Mr. Broshko has understood it, but he answered it by saying that he's not an arbitration lawyer, he don't know what would have happened.
Well, my question is not what would have happened legally, but why would they choose, in that hypothetical situation, Mr. Obradović to be the one who would claim, and not Mr. Rand? If they say that Mr. Rand is the owner of the shares and always was, why would they choose Mr. Obradović to initiate this arbitration instead of Mr. Rand?
Well, they
Why would
didn't.
they try that?
They didn't, and I don't think this was
Well-
Mr. Broshko's say, but of course you correct me. I'm not sure this brings us much further. We have seen this paragraph.
But I'm sorry, Madam President. What I'm saying that we didn't hear the explanation of Mr. Broshko, who prepared the letter, who was in contact, of course, with Mr. Rand, when they had to choose who would sue against Serbia-Canada bid. Whether
Okay.
it will be, am I on the right trace now? Yeah. Whether it will be Mr. Rand or Mr. Obradović.
But I understand your point. Who made the decision who would be the claimant in this arbitration? Or did you make the decision, or did you have a say in this decision?
well, we always followed legal advice. And as I've noted here, the initial legal advice that we had received with respect to the applicability of the treaty was incorrect. So nothing had proceeded with respect to this provision. And anything that we have, I say we, Mr. Rand, Rand Investments, the Rand children, Sembi, who is here as a claimant in front of you, was done, obviously, with legal advice, and we relied on our legal advice.
And at the time when you were advised that it should be Mr. Obradović who should send this letter to Serbia, were you advised that Mr. Rand cannot be the claimant?
Objection.
Objection.
Madam
This is
President.
Madam President,
That
objection.
goes into
This is privileged information.
I was also
attorney-client
going to
or...
interrupt. On the same thing, Madam President, I think we're trespassing into potential legal privilege.
That is the objection indeed, and I think this goes into attorney-client privilege. And frankly, I don't think it helps us at all, because we have to look at the treaty and decide who can be a claimant or who cannot.
Yes.
And what Mr. Broshko says to this is irrelevant to us, frankly. With all due respect, of course.
Thank you, Madam President.
I'll continue with another question, okay?
Good.
In your second witness statement, paragraphs 58 and 59, you said that in April 2015, the agency's representatives requested that Mr. Obradović provides an audit report evidencing his compliance with the privatization agreement, together with an updated request for approval of the assignment agreement and the previously requested bank guarantee. And it seems that this was a surprise for you.
I'm sorry, what was the surprise?
The agency requested all these documents.
Sorry, would you like to be a bit more specific? Which documents are you referring to?
That I just referred to. Could you please read para 58 and 59 of your witness statement?
Can you just remind us which witness statement this is?
Second one.
Thank you.
So the agency requested some documents to be delivered, and you say that this request represented a 180-degree turn from the position of the privatization agency. And my question is, was this the first time that the agency requested an audit report evidencing the compliance with the privatization agreement to be delivered?
No, I believe they had asked
Thank
a whole
you.
bunch of times. But
Thank you.
I think it's important to note that we had given, or it had been provided to the privatization agency in January of 2015, an audit report, which we think was very clear and should have allowed the opportunity for release of the pledge, as well as, although we thought it was fulfilled in 2011, but it should have, at that point in time, convinced the privatization agency to finish up its work and release the pledge. So we were satisfied at that point with the audit report that was in January. But the bank guarantee, yeah, that was very surprising. Nobody had ever mentioned that. And then we show up at a meeting, and at the meeting, where everybody knows that the full purchase price is paid, and where we've been working with them for, I don't know, 2 years at that point, perhaps, and all of a sudden they say, we want more documents. Oh, and by the way, you know, we want a bank guarantee, which was very significant. And of course, the reasonable question anybody sitting there asks themselves is, so you want a bank guarantee at this point to secure the purchase price that had already been paid? This seemed to us absolutely as just another attempt at stalling and putting barriers in front of barriers that had no rational basis in what the privatization agency should be doing. And my understanding is, even as this proceeded, when they continued down the road to ask for a bank guarantee, it was only a few days after that that they said, oh, now our rules have changed. So when we started, halfway in, they changed the rules to say they need a bank guarantee, even though it was never asked at the beginning. Then we proceeded, desperately trying to find a solution. They continued to ask for a bank guarantee. Then at the last time they said, yeah, we still need a bank guarantee. 3 days later, they changed the rules and said, oh, we don't need a bank guarantee now. So it was very frustrating. It was very confusing, and frankly, is not any way that a privatization agency should be conducting itself.
And have you ever checked with the rule book that you have just mentioned, which documents you should deliver?
Yeah, I've been advised on that specific matter about the bank guarantee, and what I noted is my understanding is that the obligation that they saw for a bank guarantee, again, the only reason you could have a bank guarantee is secure the purchase price, and the purchase price is paid, is that obligation started kind of halfway through our discussions and ended down the road just days after they had noted to us that it was still required. That was my understanding of it, but, you know, the rule book is in Serbian, so I can't read Serbian.
But you did have a lawyer, Serbian lawyer, in that matter. Is that correct? Helping you with the assignment procedure.
We had legal counsel, correct?
And was the only problem bank guarantee when it comes to your assignment, or are there some other documents that were missing?
We never really understood what they wanted. They seemed to be changing their mind from meeting to meeting. And anytime we said, you know, look, tell us what you need, we never really got clarity. So I'm not sure to this day we truly know what they were wanting. And it certainly seems, with the benefit of hindsight, that it didn't matter what we would have given to them.
But could it be that maybe the agency wanted to have all documents required by the rule book?
Well, I can't speak to what the agency wanted because they weren't clear.
Have you maybe checked the rule book, your attorneys, to see what documents you should file? Do you have any information about that? Did he check it?
I can't tell
You
you
can't
what he
tell.
checked or what he didn't check.
Thank you. Mr. Broško, have you spent and do you still spend longer periods of time in Serbia or not?
I haven't been there since 2019.
Thank you. Thank you, Mr. Broško, and thank you, Madam President. I have no further questions.
Thank you. Mr. Prakash?
No questions, Madam President.
Does Mr. Vasani have questions for the witness?
Madam President, I have no questions.
Thank you. Questions?
Good morning, Mr. Broško.
Good morning, Mr. Cohen.
I have a couple of questions. So you participated in all the meetings with the privatization agency, you say on behalf of Rand Investments, yes?
That is correct.
Rand Investments, is it a corporation?
That is correct.
And what is the legal relationship between Koropi and Rand Investments?
Rand Investments and Kropi are controlled by Mr. Rand.
I'm asking about the legal relationship. Is there a specific legal relationship, or is control is an economic element,
Well, Mr. Rand owns 100% of Rand Investments, and Kropi is owned 100% by the Ahola Family Trust, which is for the benefit of Mr. Rand's children. So they are two separate legal entities.
Thank you. My second question is in relation to the meetings you have with the privatization agency. So you mentioned that you contested the claim that 533 and 534 were breached. You constantly rejected this allegation.
We believe that all of the conditions were satisfied with payment of the purchase price.
But in front of the position of the privatization agency, that according to that agency, there were these breaches. So you challenged, you said, no, there was no breach.
Yes, that's correct.
And you also requested the release of the pledges.
Yes, that had been asked for since 2012, correct?
And during these meetings with the privatization agency, did you invoke the...
Sorry, what was, I'm having a hard time.
I'm sorry, I'm also wearing the mask.
Yeah, no problem.
During these meetings with the privatization agency, did you invoke the existence of a dispute resolution clause in the privatization agreement?
Sorry, did I invoke?
The existence
Yes.
of a dispute resolution clause in the privatization agreement?
I don't recall. I don't recall having a discussion about that.
Okay, thanks. In which language these meetings were conducted?
They were in both Serbian and English.
And you have someone translating for
Yeah,
you?
so it would be in English when I arrived. So I would, if I had something to say, obviously I'd say it in English, because I don't speak Serbian. Sometimes they would ask to take a conversation offline if there was something very specific and it was easier for them in Serbian, and then it would get translated back to me, either, for example, by Mr. Marketovic or Mr. Doklastic if he was there. But in a number of cases, I had the opportunity of just speaking directly with them, and they had a pretty good handle on English. So it was a combination of both.
Thank you, Mr. Broszko. I don't have any further question, Madam President.
Thank you. Mr. Broszko, towards the end of the examination by counsel for Serbia, there was a discussion about the request for the bank guarantee. Do you remember that? And at some point you said, we never really understood what they wanted, that changed at every meeting. We asked them to specify many times, but they would not specify. And then you said, was benefit of hindsight, it didn't matter what we would have given to them. I think these are your words. It would not matter whatever we gave to them. What did you mean by that?
When we were at these meetings, we would be struggling at all times to try to understand what we can do to resolve the situation. We would explain to them, for example, that we believe there's no breach. We would explain to them that audit reports had been provided to them. We had discussions about the assignment and the documents that they had requested in respect of the assignment. I knew, as I was advised in 2013, that the discussions on the assignment started. I was not there. And the discussions continued into 2014 while I was there. When it comes to the bank guarantee, that really came out of the blue for us. We were there in the room. We had believed we had provided all documents that they had asked for. We still had no movement. And when it came to the bank guarantee, we were having discussions on what we needed to provide to them and what we had provided to them for the assignment of the privatization agreement. And then they dropped this on us, which is, oh, and by the way, we need a bank guarantee. And it was very surprising at that point in time to have been told that there would be expected what is a material contribution in the form of a bank guarantee, like I said, to secure what had already been paid. So it was just very frustrating to not get clarity and to have, it seemed like the goalposts would shift. And at one point they said, because we had been waiting so long, we had given documents, and they said, well, because we've been waiting, or you've been waiting so long now your documents are stale. We want all new documents. And I think that might have been in the same meeting as the discussion or when they told us first about the bank guarantee, but I can't confirm that. So it was very frustrating, and I look back again we were really trying to provide what they want, even to bend over backwards. And it certainly appears, like I said, in hindsight, that they may not have been wanting to find a solution. And I mean, I just think that's very unfortunate, that's all.
Why would they not want to find a solution?
That's a very good question. I can't answer that. I mean, you would think that their job in the privatization agency is to try to help companies. Their job is to try to find reasonable solutions to allow these companies out of privatization to flourish. And here we were with a very well-known company trying to move this forward to inject significant capital, to show them that we had a solid plan for increasing the scalability of the business. And they just kept putting roadblocks in front of us. And even at one point, when I got a call, I was not in the meeting, but I got a call back where Mr. Markevich had, and I think I can't remember, but I think maybe Mr. Doklistich was there, where they had said that it was Mira Kostic at the privatization agency who says, we should just put this company right into bankruptcy. And so you would hope that with the privatization agency that they have a sense of a fiduciary obligation to help and promote the enterprises that are being privatized, and that they're trying to work with these individuals, again, to try to see the success of these companies. And we just didn't see it. I can't tell you why. I can just say it was a great disappointment.
Yeah, that all goes, but in paragraph 59 of your second witness statement, you say that this request for a bank guarantee and an additional report represented a 180-degree turn. Now, does that go to just to the? Do you find it?
Yeah, and maybe just to get some
Because
clarification.
when I hear you, I see that what you're saying is the bank guarantee is a new request, but I don't really see the 180-degree turn from what you're explaining here and also in your witness statements.
Madam President, what I was referring to on that 180-degree turn is the information that we were being provided. If you look at paragraph 53, where Mr. Markevich said that he met with Mr. Redzovich, who was the chairman of the privatization agency, who met with BD Agro's trustee who was dealing with the pre-pack. And we were getting at that point information that seemed to be very promising, that Mr. Redzovich thought that the demands of the bank loan were ridiculous, and that our trustee and Mr. Redzovich were increasingly confident that things were going to be addressed here. And then all of a sudden we come into that meeting, and it seems that now, instead of us having some type of positive momentum, it just seemed to just drop dead right at that meeting. So that's when I say 180 degrees, I was talking about kind of the very recent changes that we thought were positive. That's what I was referring to.
In late February, March, there was a phase, if I follow your explanations, that looked more promising. And then in April, towards the end of April, there's a return to a more negative attitude. Is that what you're saying?
That's what it had appeared to us. Now, there was not any concrete steps in February where we had heard or gotten formal correspondence from the privatization agency. You know, we were just struggling to try to understand the situation from as many angles as we could. You know, people that we knew, we would ask for their help, we would ask for their involvement to try to get some type of understanding of why we were just banging our heads against the wall. And so when in February, when things were really dire, it looked like there was a glimmer of hope, and we were, frankly, we were a bit excited. Okay, I think we're going to, if this is true, we're going to solve this. This is good. They're coming around. And then we had that meeting, and that was it. It was not good.
No, I have no further questions. And I thank you very much for your explanations.
Thank you for
That,
hearing me.
completes your examination. And that is a good time to have a break for lunch. Should we start again at 2 o'clock? Is that fine? And then we'll hear Mrs. Radovich. Is that the next witness? Yeah, good. Have a good lunch.
Hi, Vilmante.
Hello.
Hello. So did you just test it with listening to the English channel?
I didn't test it now, but they said that they tested with you this morning.
Yeah, we did it this morning.
And you are
So,
satisfied. That's good.
yeah, I'm fine with that, yeah.
I just wanted to say if you wish to test anything else, then we are here.
Okay. I suppose probably the best thing would be, you know, just before we start, for the interpreters to speak on the English channel, which is kind like when everybody's getting their headphones on, that's kind of what they do anyway, isn't it? They say, oh, this is the interpreters speaking on the English channel, so I think that will be fine.
Good, because the channel is only for you on Zoom.
Yes.
But the channel is for the others in the hearing room. So I think I'll just ask Marissa to introduce the interpreters and just to test the channel, and then you will hear. And if anything,
yes,
you will raise your hand.
Yes, yeah, and I'll double check. I can see they're not on mute anymore, so yeah, so I'll just double check that I can hear them. Is Mr. Vasani, is he going back into the hearing room then?
Be on the record now. So I think I will text you that.
Okay.
Yeah.
Okay.
Cool.
All right then.
Okay. Bye.
sa početkom u 10 časova. Konstatujem
apologies for having kept you waiting. We're pleased that we have Mr. Razani in person now, and that this test was negative. So we're reassured. Yes. I should also say that I took the initiative of closing the window there because I thought you must be very cold sitting there. But if you prefer to open it again, you can do. Yeah, it's open again, actually. Yeah, good. Fine. So from now on, we'll have interpretation, and I see the interpreters are there, and you know which channel is which. Ms. Radović-Janković, do you hear me well when I speak?
Da, čujem vas.
Yes, I do. Thank you.
Da li vi mene čujete?
Can you hear me?
Absolutely. So for the record, can you confirm to us that you're Branka Radović-Janković?
So, hello everyone. Yes, I can confirm that I'm Branka Radović-Janković.
You have been was the privatization agency until 2016, is that right?
The mic is off. Apologize. Yes, I worked there right from the beginning up until 2016 when the agency was closed, or when I actually stopped operating.
And what is your do you have a current position elsewhere, or you retired?
Ne, ja sam ta...
I retired then, and for 6 years now I've been retired.
Thank you. You have provided us with one written statement that was dated 24th of January 2020.
Are you asking about the date when I made the statement? Is that what you're asking me?
I was just wanting you to confirm that you have made a statement. Yes.
Dala sam i...
Yes, and the date is the 24th of January 2020.
Fine, and you have the statement there in front of you.
Da.
Yes, I have it.
And you also have in front of you the witness declaration. I think you have a copy in Serbian, so I would like to ask you to read it now.
I solemnly declare upon my honor and conscience that I shall speak the truth, the whole truth, and nothing but the truth.
Thank you. So I will first turn to Serbia's counsel for direct questions, please. Ms. Mihaj?
Thank you, Madam President. Ms. Radović, would you wish to correct something in your written witness statement, maybe?
I apologize. I made a technical error in point 2, which discusses my career. This might cause confusion because I have one version in print, so I will not make a mistake, I believe, if in the third line of paragraph 2, instead of the word January, the word December should be the correct choice. And in line 8, instead of the word March, we should have the word February. So these are the only two corrections that I would like to make.
Hvala.
I'm sorry, Ms. Radovic, did you refer to March? Because I don't see March in para 2 of your witness statement. I think that you would like to refer to June.
Jun, izvinite, Jun.
My apologies. Yes, I don't have that version of the declaration here. You are right. Yes, it should say instead of June, it should be February.
Thank you, Madam President. I have no further questions.
Thank you. So I'll turn to Claimant's counsel. Mr. Mizetic, are you the one asking the questions?
Yes, Madam
Yes,
President.
please.
Thank you, Madam President. Good afternoon, Ms. Radovic-Jankovic. My name is Luka Mišetić. I am counsel for the claimants in this arbitration. Let me just ask you, if you don't understand a question that I pose to you, please ask me to rephrase the question, and I'll be happy to do so. And the other point to keep in mind is that we're communicating through interpretation, so if you would give me some time to finish my question, I will give you some time to complete your answer so that we don't speak over each other. Do you understand?
Da, razumem.
Yes, I understand.
Thank you very much. Just to pick up on Madam President's questions about your background, I just wanted to further clarify. I understand from your witness statement that from February of 2007 until January of 2016, you were the special legal advisor and specific legal advisor to the director of the agency. Is that correct?
Yes, that is correct.
Okay.
Menjali su se funkcije.
I was special legal advisor for a while, then I was a specific legal advisor, all in the office of the director.
And could you explain to us what the special legal advisor and the specific legal advisor does?
Essentially, if we're talking about the kind of work that is done, there is no major difference. In both of these functions, I was actually doing the same legal work. What changed was the systematization of positions, and the names changed from special legal advisor to specific legal advisor.
Were you providing legal advice to the director?
Yeah. Among other things, yes, I gave him some legal advice.
From 2013 to December 2014, you were a member of the Control Commission. Is that correct?
No. Yes, that is correct. In this time, I was a member of this commission, and I was a member of the commission in some earlier times. I don't think it was until February 2014. I think it was until August 2015.
President of the commission from December 2014 to August 2015, correct?
Tačno, tačno.
That is correct.
Okay, turning to your witness statement, at paragraph 8 of your witness statement, you say that you attended meetings held at the Ministry of Economy in 2014 and 2015, which related to the assignment of the agreement to Koropi, correct?
That is correct.
Do you recall how many meetings, such meetings, you attended?
I can't remember precisely how many meetings there were, but I think I was at these 2 meetings at the ministry.
In 2014 and 2015, you did not attend any meetings concerning the assignment of the agreement to Koropi, where Mr. Đura Obradović was present for the meeting, correct?
Ja,
I was at the meetings in the ministry in 2014 and 2015, and as far as I can remember, Mr. Đura Obradović was not attending these meetings.
I'd like to show you Claimant's Exhibit 273. And this is Mr. Obradovic's letter of the 1st of August 2013 to the Privatization Agency requesting assignment of the agreement to Koropi.
Mogu da pogledam?
I just you've seen this document before.
I can't remember. I handled a large number of different documents. I was authorized to sign documents of the agency, and I handled many documents. We worked with some 4,000 companies, and you can see for yourself how many different documents we have that address this case only. So I can't remember exactly whether I saw this particular document.
Okay, well, this is the letter that Mr. Obradovic sent to the Privatization Agency requesting assignment of the privatization agreement to Koropi. The Privatization Agency's view, according to your statement, is that Mr. Obradovic was the owner of BD Agro, correct?
Mr. Obradovic was the owner of BD Agro, and I happened to sign the agreement, the sale and purchase agreement, and Mr. Obradovic, as the owner of the shares of BD Agro that he bought, was registered in the Registry of Commercial Entities, where all commercial entities were registered. So all documents, all letters, all meetings were held exclusively with Mr. Obradovic. And for us, he was the owner of the capital.
For you, in the Privatization Agency, only Mr. Obradovic could seek assignment of the privatization agreement, correct? He was the party to the agreement?
Yes.
Yes, he was the signatory on the sale and purchase agreement, and it was only him who could assign the agreement to a third party under certain statutory conditions.
Okay, but if I understand your testimony, despite the fact that it was his rights under the agreement, you never attended a meeting in 2014 and 2015 where Mr. Obradovic was present, even though the discussion, according to your statement, was related to the assignment of the agreement to Koropi, correct?
Whether I was at these meetings, I can't remember, to be honest. It may have been the case, but I can't claim. We had many meetings, and I can't state with absolute certainty that I was at a certain meeting.
Okay, but I understood your earlier answer to be that you don't recollect seeing Mr. Obradovic at any of these meetings in 2014 and 2015. Did I understand you correctly?
In 2014 and 2015, we had meetings at the ministry, and as far as I can remember, Mr. Obradovic did not attend these meetings, or he was present physically, but he was asked not to attend the meeting, given that Mr. Broško, who was the representative of Mr. Rand, scheduled the meeting with the ministry.
Well, let me turn to that meeting that you've raised, and that's the 15th of December 2014 meeting. And this is Respondent's Exhibit 38. These are the minutes of the meeting. You were present for that meeting, correct?
Yes.
Okay. And I think you've already alluded to the fact that Mr. Obradovic attempted to attend the meeting, correct?
I think that's the meeting, but I can't say with absolute certainty whether it was that meeting.
I think the parties
Ja sam
are in
samo rekla da sam jednom...
I just said that on one occasion I saw Mr. Obradovic, but he did not attend the meeting.
I think the parties are in agreement that there was a meeting on the 15th of December 2014 where Mr. Obradovic attempted to attend but was asked to leave. And these are the minutes that you're looking at of that meeting. Do you recall who invited Mr. Obradovic to the meeting?
I can't remember because the meeting had been organized by the Ministry of Economy and not the privatization agency. So we in the agency did not make the list of participants or people who were supposed to attend the meeting.
Were you present when Mr. Obradović was asked to leave?
Yes, I was present.
Who asked him to leave?
I can't remember that at this moment, whether it was one of the representatives of the ministry. I don't remember who exactly.
Was Mr. Markicevic asked to leave?
As far as I can remember, no, he did attend the meeting.
Do you know what Mr. Markicevic's title was?
I think Mr. Markicevic at the time was the director of BD Agro Dobanovci, and that it is in this title that he attended the meeting.
If I understand correctly, your understanding would have been that Mr. Markicevic worked for Mr. Obradović, who was the owner of BD Agro, correct?
I only said that Mr. Markicevic was the director of BD Agro. I did not make any mention. I don't know which word you mentioned. Well, could you please repeat your words in your questions? In your question?
That he worked for Mr. Obradović.
Da je radio za gospodin.
I can't put it in these words. I know he was the director of BD Agro.
He was the director, in your view, he was the director of a company owned by Mr. Obradović, correct?
Yes.
Yes.
But he wasn't asked to leave the meeting.
No, he wasn't asked to leave the meeting, as far as I can remember.
Did Mr. Markicevic's presence at the meeting alongside Mr. Brashko suggest to you that Mr. Markicevic worked for Mr. Brashko and not Mr. Obradović, who had just been asked to leave the meeting?
I can't remember that.
Well, subsequent to this meeting, did you have a follow-up meeting with Mr. Obradović?
I apologize, I can't remember that either.
Da li smo imali
I don't know whether we had a subsequent separate meeting with Mr. Obradović. Are you asking about a meeting at the privatization agency?
Anywhere, Ministry of Economy or the Privatization Agency?
Ne.
That's you. I can't remember. I'd rather not guess. I just don't remember.
Well, you were having a meeting with the party that was to receive the assigned agreement, correct?
Yes, we discussed the assignment of the agreement.
Did anyone at the Privatization Agency or the Ministry of Economy think it would be appropriate to have a conversation with the actual owner of the company on the other side of the assignment agreement?
I can't respond to the question whether someone from the privatization agency thought this or that, but this legal transaction would not have been possible without the consent of Mr. Obradović, because according to law, he was the guarantor of the agreement and he was the one responsible for the enforcement of the obligations.
Okay. Well, let's look at the minutes of the meeting. These are minutes prepared by the Privatization Agency, correct?
From which meeting? Are you referring to the meeting that we just discussed, or another meeting?
Minutes of the 15 December 2014 meeting, which should be in front of you right now. These minutes were prepared by the Privatization Agency, correct?
Da, vidim ovdje da
Yes, I see. It's called a note from the meeting, which was drawn up by my former colleague, Madam Kostic, as it says here.
Yes, and it identifies you at number 5 as having been present. Do you see that?
Yes.
Correct, I can see it.
Identifies at number 10, Aaron Broshko, Executive Director, Rand Investments. Do you see that?
Da, vidim.
Yes, I see that it says so.
Minutes do not reflect the word koropi at all.
Samo sekund.
Well, just a second, I need to go through it then.
Da, vidim ovdje samo kratak opis.
Yes, I can see here that it's just a brief description of the topics discussed during the meeting and what is the ministry expected to prepare for the next meeting.
It says, if you look at the last sentence of the notes here, it says the representative of the entity of privatization, right, have committed to prepare for the next meeting, which is agreed in principle to be held on the 17th of December 2014 in the ministry. The materials on the state of the mortgages registered on the property of the entity undergoing privatization as a collateral warranty for the liability of third parties.
Da.
Yes.
Why would the ministry and the privatization agency ask the person they believe to be seeking assignment of the agreement to start gathering information such as the state of mortgages on the registered property? Why not ask Mr. Obradović to do that?
Pa zato što...
Because the meeting was attended by Mr. Markicevic, who was the director of the company. It doesn't have to be done by Mr. Obradović. Such information can be provided by the director of the company.
He's the director of BD Agro, which is not a party to the privatization agreement, correct?
On nije...
The person is not a contractual party, but it doesn't mean that he cannot be a director and he cannot assume certain responsibilities. The director is, as far as I know and remember, appointed by the steering committee, steering board of the entity undergoing privatization.
And you never saw a document appointing Mr. Markicevic as Mr. Obradovic's personal representative, correct?
Correct. Personally, I haven't seen such a document.
Didn't this give you the understanding that Mr. Markicevic was working for Mr. Broshko?
Ne znam, sad nisam baš...
I'm not sure I fully understood your question. Is that why I didn't understand that he was working for? I'm not sure I understood that, but Mr. Markicevic attended the meeting in his capacity of the director of BD Agro. Yes, he appeared in the company of Mr. Broshko, and from what I understood, Mr. Broshko was the representative of Mr. Rand, not Mr. Markicevic.
As I understand your testimony now, in 2014 and 2015, you attended meetings about the assignment of the agreement where Mr. Markicevic and Mr. Broshko attended, but Mr. Obradović did not, correct?
Pa ja sam
Yes, I have said that already.
Any conclusions from that fact about who Mr. Markicevic was working for?
pa ne razumem.
Why would we have to draw any conclusions about that? I don't understand. Mr. Markicevic came as a representative of BD Agro. We discussed the assignments, possible investments into the company, as far as I remember.
I guess my point is, if you know that you didn't receive a document that Mr. Markicevic was Mr. Obradovic's personal representative, then who are you discussing assignment of the agreement with on behalf of the buyer?
First of all, I said that it was the Ministry of Economy which scheduled this meeting. It wasn't the Agency for Privatization. We were not designated as the entity that can invite anybody to that particular meeting, but Mr. Broško, as the director of the company, was able to discuss the conditions for assignments. It was possible for us to tell him what he needed to fulfill for the entity undergoing privatization to be taken over by a third party. Though the topic of the meeting was not only that, I think it was broader than that. I think we were discussing some unmet obligations, possible investments in the future should the assignment happen. Then there were discussions about bankruptcy over the company, about the pre-packaged reorganization plan. All of these topics were discussed, not just the assignment.
Let me turn your attention to a different part of your witness statement, which is section 3 of your statement, which begins in the English on page 4. And if we could start with Claimant's Exhibit 30, please. I'd ask you to take a look at this document and let me know if you've seen this document before.
To je taj dokument, jel? Izveštaj o kontroli.
That's the report on the control which was performed.
You can look in the hard copy, just so you know, we have a hard copy in Serbian for you if you want to see the original in Serbian, and then in front of you, you can see the translation in English if you wish.
Dobro, za sada vidim samo naslov.
You can.
For the time being, I can see only the title.
Izvinite, nisam razumela. Da, imam pred sobom.
So I have the paper version in front of me.
You've seen the document before, and if you know what it is.
Ne mogu sad stvarno da se setim da li sam
I truly cannot remember if I've seen this document before, if I held it in my hands, but I see that it is a report on the control of performance of the obligations of the buyer under the agreement on the sale of socially owned capital of BD Agro.
Yes, and this is an internal report of the privatization agency, correct?
Da, pa piše na njemu.
Yes, that's what it says. So it's an internal document.
At page 2 of the agreement, of the report on control.
Da.
It says, second paragraph, the above stated obligations, meaning the performance obligations, are in effect during the term of the agreement, October 4, 2010, which has been extended since the buyer failed to pay the 6th installment of the sale and
Da,
purchase
da, da.
price. On which basis the third
Dobro, ja vidim šta tu piše, da navede
I see what it says. These obligations are valid during the validity of the period, and then the date is here, which has been extended because the buyer has not paid the 6th installment of the price. And on this basis, he was given the third and last additional period. I'm guessing when I say additional period, it means to pay the price, to pay the final installment to the 6th one. That's probably what it refers to.
understand this correctly to mean that the term of the agreement expires upon the payment of the last payment due?
Well, generally speaking, when it comes to all agreements where we have bona fide buyers, the payment of the price is the final act that is done. But it often happened, like in this case, that the price has been paid, but the contractual obligations have not been fulfilled. In such cases, the agreement itself cannot be deemed fulfilled. All of the obligations under the agreement have to be fulfilled. Just the payment of the price does not mean we can forget about the performance of other contractual obligations.
We'll get into that in a few minutes, but for now, I just was interested in what this paragraph of this document suggests. And in this paragraph, it suggests that the term was to expire upon the payment of the last of the purchase price, correct?
ovde tako piše.
Yes, this is what it says, so it seems.
If we turn to page 8 of this document.
Sorry, I would like to have one explanation, which is a linguistic one. Is in Serbian term and termination synonymous or not?
The interpreters apologize. We are not sure we quite understood your question. The term termination is synonymous with which other term? Did we get that fully? A microphone, please, so we can hear you. Thank you.
Term, and whether the term means termination.
Are you asking me or the witness?
Everyone knowing Serbian and English.
Maybe the best thing would be to ask the interpreters. The word term in English means the end, the maturity of a contract, whereas termination means the act by which you end a contract, which is a different thing. And so the question is whether these two words are the same in Serbian or not. Is that right?
We have understood the question. No, they are entirely different. The term means validity of the period, and termination is something completely different. It's to terminate the validity, so they're entirely different in Serbian language. I hope that clarifies the question.
Yes, thank you.
If we could turn to page 8 in the English. In the section below 5.3.1. The second paragraph begins, "The ban on disposal of shares expired on October 4, 2007, but given that the contractual provision and the share pledge agreement stipulate a pledge in favor of the agency until payment of the complete sale and purchase price, the buyer was notified via a letter announcing the control to ensure the excerpt from the CSD and CH on the state of his proprietary and pledge account on the day of the scheduled control." Do I understand this text correctly to mean that the agency understood that the pledge was in favor of the agency until payment of the complete sale and purchase price?
Pa malo pre sam
I was referring to that a while ago. The pledge was introduced on the shares, and that was addendum 1 to the agreement, which stipulated that the pledge would have a term, a validity term of 5 years, or until the payment of the purchase price. Was that what your question was referring to?
Okay. If I could then, page 21 of this same document that discusses paragraph 533 of the privatization agreement. And if you could read the paragraph, I won't read the whole thing out loud to spare the interpreters, but the paragraph immediately below the bolded section on 533 that begins, "We highlight that over the course of 2007."
Hoćete ja da ga pročitam naglas, da? Dobro. Da, pročitala sam.
Okay, so
I've read it.
This report, the privatization agency was aware that the percentage of total disposal is decreased for the percentage based on the reduction of the breeding herd from 2007, which was caused by an order of the Ministry of Agriculture.
Dobro, to je...
That was the auditor's report. It's a fact that came from the auditor's report.
Now, if we could turn to Exhibit C31, and I would note that the date of this document is February 25th, 2011. And if we could turn to Exhibit CE31. It's dated the same day, February 25, 2011. received on the 1st of March 2011. Have you seen this document before?
Ne znam.
I don't know. I cannot say that I've seen it. Perhaps I have in the materials for the Commission, but I can't really say it with certainty that I have seen it.
This that was given to BD Agro of an additionally granted term for fulfillment of contractual obligations. Do you see that in the subject line?
Yes, I do.
Turn to the last page. Right there. You see the dash lines there. This is the request of the agency of what BD Agro had to do. Do you see that? It alleges immediately above that that there is an additionally granted term to submit a report stating whether the buyer has fulfilled its obligations referred to in items 533 and 534 of the agreement, as well as the statement relating to the following circumstances. Do you see that?
Da.
Yes, I do.
It's not the case that the agency told the buyer here that if Inex and Crveni Signal simply repaid the money, the privatization agency would not terminate the agreement, correct?
Izvinite, gde je to?
I apologize. Where does it state that? Is it stated here?
That what you've just read doesn't state that, does it?
To što sam
What I have read is an audit report, and I don't know now if we accepted this audit report. I don't know. I wasn't working in the control, and I really couldn't answer this question with certainty as to whether we had accepted this position of the auditor or not. Since this was followed by many audit reports that had to do with both items 533 and item 534.
Fault, there's some confusion about what the document is that you should have in front of you, which is Exhibit CE 31. It's a letter from the agency to Mr. Obradović. Do you see that?
Vidim.
Yes, I do. And it's from 2011.
Notice granting him an additional term for fulfillment of contractual obligations, correct?
Da, yes.
Yes, it is.
This letter is to advise him of what he needs to do in order to be in compliance with the agreement, correct?
Da.
Yes, correct.
You can take your time and look through the agreement, through the document if you need to, but nowhere in the letter does it say that to Mr. Obradović that all he has to do is have Crveni Signal and Inex repay the money and the privatization agency won't terminate the agreement, correct?
Sve dok
all the time up to the last audit report, in the audit reports by the auditor hired by the entity undergoing privatization to which this entity submitted documentation, said that the obligation from 534 had not been met. As to 533, I cannot remember precisely what it said there. But I do not understand your question. What's the point of your question? If Crveni Signal, if Mr. Obradović had returned the money he had loaned to third parties, would that have been considered as meeting the obligation?
Question than that, but it's, did this letter tell Mr. Obradović that he would fulfill all of his contractual obligations if Crveni Signal and Inex repaid the money?
To my knowledge, Mr. Obradović would have met the contractual obligations since he was in breach of item 534 if he had removed the mortgage or if he had returned the money that he had given as a loan to third parties, since this was in breach of provision 534 of the agreement. So he should have done either one thing or the other. But I believe another witness could tell you much more about this, because I'm really not well versed in these economic matters. I'm a lawyer and could make mistakes answering this.
More interested in your legal analysis because of your function in the agency, but I do want to follow up with one point. Do you see at the top of the screen, it alleges a violation of 533, correct?
Da.
Yes.
Signal and Inex wouldn't cure a violation of 533, correct?
Da.
Yes, but provision 533 was not a reason to terminate the agreement. It was just 534.
Let the buyer know that the agency was no longer alleging a breach of 533.
I cannot say this with certainty, but I know that I advocated the view that in 533 it was force majeure because there was leukosis in the cows, and that the cows had to be culled because the Minister of Agriculture had asked for this. So in this case, the thresholds of 30% had not been reached. And I didn't attend further meetings of the Commission. On the 19th of June was the last meeting of the Commission that I attended. I didn't attend further meetings. I don't know if any were held. I did not attend the meeting of the Commission where the agreement was terminated, but according to my knowledge, it was terminated because of 534 and not 533.
Question was slightly different, and you've answered it somewhat, because now you're talking about discussions within the privatization agency about 533 in 2015, correct?
Da.
Yes, correct.
2011 to 2015, the agency was continuing to allege a breach of 533, which is why you needed to discuss it in 2015, correct?
But
yes, those were the audit reports. And they never fully stated their opinion as to whether there was a breach there or not.
Makes no reference to 533, correct?
In my witness statement, I don't make reference to 533. Yes, in my statement, I talk about 534 because 533 was not the reason to terminate the agreement.
If we look at paragraph 13 of your statement, you say that, quote, the agency received an opinion from the Ministry of Economy stating that the agreement should not be terminated since it would not be economically justified.
Tačno.
Yes, correct.
Case simply that the agency received an opinion from the ministry, correct? The agency requested the opinion of the ministry, correct?
Ne mogu se...
I cannot remember now whether we had requested an opinion. It's possible that we had requested it. We did not request only an opinion in this privatization. We requested some opinions from the ministry on many occasions. It's possible that we had requested one in this case because Mr. Obradovic had approached the ministry repeatedly with letters, with complaints, through meetings, and each time we wanted to know what the position of the Ministry of Economy was. It doesn't mean that we accepted it or not. As you can see in this case, the ministry said it was economically justified not to terminate the agreement, but we terminated it because the ministry had taken into account only the economic aspects of the privatization without taking into account the legal aspects.
Before we turn to this opinion, you stated that Mr. Obradovic had approached the ministry repeatedly with letters, with complaints, through meetings, and each time we wanted to know what the position of the Ministry of Economy was. You're referring to complaints from Mr. Obradovic to the agency's allegations that he was in breach of 533 and 534, correct?
Pa sad ne mogu ta...
I cannot say precisely here. I don't have the letters here in front of me, the letters he sent, but probably yes, because we were insisting all the time on the obligation from 534 to be met.
Claimant's Exhibit 33, please. You've seen this opinion before, correct?
Da, jesam, jesam.
And this is
Videla sam.
Yes, yes, I have seen it.
the opening paragraph of the ministry's opinion references a letter from the privatization agency regarding the case of the privatization of ADBD Agro Dobanovci, requesting further instructions and directions for additional actions. Correct?
Yes.
Yes, correct.
Your recollection that the agency was the one that asked the ministry for an opinion in the case of BD Agro?
Da, tako priziv.
Yes, that's what results from this letter.
Would the agency need an opinion of the ministry if it's a cut case to you?
Well, probably because it was a really big entity undergoing privatization, a major agricultural holding for the state. And the aim of privatization was not to terminate agreements, but we tried to keep the agreements going wherever possible. We tried in every possible way to keep this agreement with Mr. Obradovic as well. And we probably approached the ministry for this reason, but as you can see, in the end, we didn't act in accordance with the opinion of the ministry. The ministry is the supervision authority. It supervised the work of the agency in terms of the privatization law and the law on the privatization agency. And we were not supervised only by the ministry. We were also supervised by the government. Through the ministry, we had to send reports to the government, reports on our work, and then the government sent those reports to the National Assembly that had a special privatization committee that discussed all privatization cases. So in every privatization and every time we needed to terminate an agreement, we tried to see whether we could keep a privatization agreement in force or not.
is it your testimony that at the time it requested this opinion from the Ministry of Economy, the privatization agency was already convinced that Mr. Obradović was in breach and that the agreement should be terminated?
We had granted many deadlines to Mr. Obradović for performing the contractual obligations, primarily the one from 534. In this way, we wanted to be forthcoming with Mr. Obradović, and we didn't want this agreement to be terminated until we understood that all the possibilities had been exhausted to keep the agreement in force. As long as we believed that Mr. Obradović would honor the agreement, because he was giving us reassurances that he would pay, that he would return the money, that he would remove the mortgages, we were given additional deadlines. So all this time we were forthcoming with Mr. Obradović.
Didn't answer my question. My question was, at the time the agency sought the opinion of the ministry, was the agency already convinced that Mr. Obradović was in breach and that the agency was required to terminate the agreement by law?
Well, we were aware that 534 had been violated and that the agreement could be terminated. All the audit reports say that this obligation from 534 had been violated, and all the reports from the Center for Control that were sent to the Commission that took the final decision said that the agreement should be terminated. Their suggestion was to terminate the agreement. But each time we tried again and again and again, who knows how many times, to give an opportunity to Mr. Obradović to meet this contractual obligation. After all, he was aware of the possible outcome, because in other privatization cases he had breached such contractual obligations and he had rectified it there, but in this agreement he did not do it.
The agency was of the view that it could be terminated, and my question was whether the agency was of the view that it was required by law to terminate the agreement.
Well, the law is clear. Article 41, paragraph 1.3 says that disposal of assets in favor of third persons is a reason to terminate an agreement. But this doesn't mean that the buyer couldn't have met this contractual obligation and removed this reason for termination. He could have done it, and he had many opportunities to do it, and the agency really was forthcoming with him on many occasions.
The opinion on the screen, the ministry says it reviewed all delivered exhibits as well as the website of the commercial entity and informed the agency of the following. We think there is no economic justification to terminate the agreement of sale of socially owned capital of the subject privatization, having in mind that the buyer paid the entire amount of the sale and purchase price, that he used the funds received from disposal of the property to comply with the obligations of the subject of privatization towards the employees, state creditors, and commercial banks, mostly through assignment payments, since his bank account was blocked, that the stated disposal of the property did not threaten the continuity of business activities of this company, as well as that the buyer of the capital achieved the highest possible level of organization of this type of primary agricultural production with the application of the latest methods in the field of primary production. The ministry never changed its opinion that there was no economic justification for termination of the agreement, correct?
No. In their supervision, the ministry practically said that the agency should act in line with the law. It did change its opinion in a way because it took into account everything that the agency sent in its material in terms of the fulfillment of contractual obligations or non-fulfillment of obligations by the buyer, BD Agro. But Mr. Obradovic had been in breach of 534 before he paid the sale and purchase price.
Position is that it changed. The change in opinion is implied in the April 7, 2015 order issued to the privatization agency, correct?
No, it wasn't an order. It was just an opinion. An opinion does not bind the agency. The agency is a public service that's independent in its work, independent in its decision-making, finances itself, and is not obliged to accept opinions. It accepts opinions when it believes them justified and purposeful. In this case, it wasn't legally possible to accept this opinion because that would have introduced a practice that wouldn't have been good for privatization. That would mean that any buyer could pay early. Mr. Obradovic didn't do it early before the deadline. It was a bit after the deadline. But they could pay after 2 or 3 years the price and thus amnesty themselves from meeting the contractual obligations. What would that have meant? The aim of privatization wasn't only to sell the socially owned capital and turn it into private capital. The aim of privatization was also to boost Serbia's economic growth, to have social security, to have more jobs, to foster technological development. And what would we have done in that way? We would have a new practice where everyone would pay the price after 2 or 3 years. They wouldn't invest anymore. They would dismiss the workers. They would sell the assets. And then what would the privatization have achieved?
Ms. Radović-Janković, I appreciate the answer, but I'm not sure that it was directly on point to my question. So let me ask my question again. The document that you see in front of you concluded that there was no economic justification to terminate the agreement. The ministry never explicitly subsequently stated that this opinion was incorrect. Do you agree?
I agree that we did not get an opinion which said our previous opinion is not valid. I can agree with that. But I can't agree that the Ministry of Economy did not do the supervision over the privatization agency work and list the things that had not been performed. And then they said the agency give them an additional term of 90 days within which they can fulfill the obligations that so far have not been fulfilled.
Getting back to the document that's in front of you, you say in your statement that this opinion of the ministry did not address the legal aspects of the problem, i.e. whether the legal conditions for termination of the agreement had been met. That's at paragraph 13 of your statement, correct?
Yes, correct.
Okay. The date of this opinion was 30 May, sorry, yes, 30 May 2012. You say it didn't address the legal aspects of the problem, and as a result, the agency sought the opinion of an outside law firm to address the legal aspects of the problem, correct?
Yes. We requested an opinion from a law firm which was engaged to do privatization disputes for the agency, and the agency, or it was common for our agency to seek the opinion of the law firm on a specific legal point. We did not accept the opinion of the law firm either, because we were of the opinion that it was not in line with the law. The opinion was based on the provision of the agreement without paying attention to the imperative provision of the law, which says what the reasons are for an agreement to be terminated.
Opinion, which is Claimant's Exhibit CE 34. Now, if the agency was already convinced of the legal aspects of this, why would it seek the opinion of the Radović-Ratković law firm?
I do not understand why we should not have asked. This was not the first time for us to seek their position on an issue. We often did that. We simply wanted to have several different opinions, several different perspectives, and then the Commission eventually took a decision based on its conscience and the law.
With me that government agencies don't typically spend money on outside law firms to get opinions on things they already have conclusive legal opinions about, correct?
I do not agree with you. External legal assistance is often retained. In the Ministry of Economy and in our ministry as well, we often had foreign consultants, and these foreign consultants usually drafted these agreements, and many ministries would retain foreign consultants. This was quite common.
Okay, so you, as I understand your testimony, the agency sought an outside legal opinion even though the agency already was convinced of the legal aspects of this case, correct?
Correct. It was not an external firm. It was a law firm which did the work for the agency. It had already been paid for this type of work. And if I can repeat, this was not the first time that we were asking for an opinion from the law firm.
This is a law firm that the agency trusted, correct?
Yes. It's one or two or three. I can't remember how many exactly there were.
Let's take a look at page 3 of the opinion. Under the section, under the section marked fulfillment of the agreement, it says, as mentioned above, the reasons for termination of the agreement are stipulated in Clause 7 of the agreement and Article 41A of the law on privatization. Do you see that?
Yes, I can see that. My apologies.
Okay. You need some water? Or?
proći će.
I think I'll be all right, thank you.
Do you see that the law firm actually did consider Article 41A of the law on privatization in arriving at its opinion?
Jeste.
Yes.
If we look above in the document, it discusses Article 534, and then the underlying text says, as per this agreement and the law on
Yes.
privatization, violation of this obligation is not sanctioned by termination of the agreement. You see that? Do you agree with me that the law firm considered both the terms of the agreement and the law on privatization and advised the agency that termination of the agreement is not sanctioned by either the law on privatization or the contract terms themselves?
Mislim da je
I do not agree with the law firm's opinion. I lost my good voice or reputation, as we say in Serbian. I do not agree with the opinion of the law firm that neither the law nor the agreement speak of this possibility to terminate the agreement unless it's explicitly stipulated by the agreement. And the law in Article 41, paragraph 1.3, I think there's no need for me to read it again. So by law, it is not possible to dispose of the assets in the way in which these assets were disposed. So to dispose of the property in the way as regulated by Article 534 of the law, and Mr. Obradović or BD Agro disposed of the property for the benefit of third parties. And the privatization law says one cannot dispose of the property in contravention of the agreement. Therefore, Article 534 cannot be exempted from the group of provisions that are, by force of law, reasons for termination.
I'm sorry, Madam President, maybe we should ask the witness, does she need a little break?
I was asking myself this, and then I thought it was going again fine, but maybe I was wrong. Would you prefer that we take a short break now? We're going to take a break at some point in any event. What time is it? 20 past. Would you prefer, so you can recover your voice?
Ne, hvala vam. Ja mislim da...
Thank you very much. I think my good voice, figuratively speaking, is now okay. I don't think we should make a break for me now, but if it's the time for a break, according to the schedule, we can do it. I have certain allergies that are affecting my voice, but I'm okay for now. Thank you.
Yeah, in a little while, and then in about 10 minutes or a little bit more, you see where there's a good place in your sequence to interrupt.
Yes, thank you, Madam President. Let me just stay on this document then, and if we could go to page 5 of the document. And I won't spend a lot of time on it, but the law firm Radović-Ratković advised the agency that the issue of the disposal of cattle was a matter of force majeure, correct?
Yes, correct.
And if we could turn to the final paragraph of the document. the conclusion of the firm was that besides the fact that there is no economic justification, there is also no legal basis for termination of the said agreement on sale of socially owned capital. And it also then cautions, in this case, harmful consequences for the privatization agency and thus for the budget of the Republic of Serbia would be enormous. Beside the repayment of full sale and purchase price, plus the appropriate legal default interest, the buyer of capital would also have the right to request and get compensation of all the damages. Correct?
That is what it says in the opinion drafted by the law firm. But this does not mean that this was the opinion of the agency.
Of the 11th of June 2013, the agency was in possession of an opinion from the ministry that there was no economic justification and an opinion from the law firm of Ratkovic Radovic that there was no legal justification for termination, correct?
Yes, correct.
And who made the decision to ignore these opinions?
The final decision was taken by the Commission based on the supervision conducted by the Ministry upon the proposal of the Center for the Control of Contractual Obligations.
And that occurred in April of 2015, correct?
Yes, correct.
So it took 2 years after these opinions to get a decision on whether to accept or reject the opinions?
Yes, but what you are not mentioning is the fact that we tried to keep the agreement going. We did not want to see the agreement terminated. We kept giving them additional deadlines. We were trying to keep the agreement effective all the way up until the end. But again, let me repeat, the purpose of the privatization agency was to keep as many agreements as possible in effect, including this one, particularly if the case was of major substantial privatizations, and BD Agro was one such case.
Well, I'd like to ask you just a few questions about that period of 2 years between the opinions and then the decision of the ministry. You are familiar, are you not, with the fact that the Ombudsman of Serbia also opened his own investigation into the BD Agro situation, correct?
Yes. The Ombudsman did not open his case. He sent a letter to the privatization agency asking what was going on in this case, and we responded to the letter. And the Ombudsman practically asked from us to give a decision. He did not suggest as to whether we should issue a positive or a negative decision. He just wanted to have a decision.
Turn to one such piece of correspondence. This is Claimant's Exhibit 43. And this is a letter from the privatization agency to the Ombudsman dated November 14, 2014. It says the subject is in response to the Ombudsman's letter of October 30th, 2014. And if you read the first sentence, it says, in a letter submitted to the privatization agency on October 31, 2014, you asked the agency to provide the reasons why it did not terminate the agreement on sale of capital of the privatization of subject BD Agro AD. Do you see that?
Da.
And he says,
yes, I can see that.
Even though it determined that the agreement had been breached. Do you see that?
Yes, I can see that.
It's correct, is it not, that the what the ombudsman was doing was asking the agency why it wasn't terminating the agreement.
Okay, he was asking a question. We gave him our explanation. And he acted within his powers as set by law. And he would be normally approaching other agencies with similar questions on other issues. And he asked us this, and we explained why we had not. But the opinion of Ombudsman does not have a binding nature on us.
Document as to the reasons you provided to the Ombudsman for not terminating the agreement. And if we could look at page 3 of the document. When I say you, I mean the agency. And if you look at, in the English, the third paragraph from the top of page 3,
Nije to stranica broj 1?
Isn't it page 1 where this is discussed, where there's a list of why, the list of reasons for the termination? Are we looking at that? I can't see any mention of those on page 3, so can we check the page, please?
talk about the first point on page 1 that you've highlighted, which is there are several reasons why the agency did not render a decision on termination of the agreement. And the first point is unresolved legal issue regarding fulfillment of contractual obligations. Right?
Yes, that's what it says here.
And if you go to page 3, there's the detailed discussion of what those unresolved legal issues are.
To je stanica 2.
I'm just so you understand, I'm talking about page 3 in the English, which might be different in the Serbian version.
Da, zato sam se ja
And that's what confused me. Ako možete sad pogledati taj dio.
So it says in that paragraph that begins, even though the agency asserted that the conditions were met for termination of the agreement, in this concrete case, besides the opinion of the competent ministry, that there was no economic justification for termination of the agreement, it turned out that the legal basis for termination of the agreement was also disputed, not only in the sense of fulfillment or failure to fulfill obligations from Articles 533 and 534 of the agreement, but also in the validity of the privatization agreement, that is, expiration of terms for fulfillment of buyer's obligations at the moment of full payment of the purchase price, as stipulated in the agreement. It then goes on to say that the violation of Article 533 occurred as a result of force majeure. And then it says in that same paragraph, last sentence, violation of the obligation referred to in Article 534 of the agreement, encumbering with pledge the fixed assets for third-party benefit, is not stipulated in the privatization agreement as a condition for termination. The next paragraph says, if the agreement was to be terminated regardless of all the aforementioned circumstances, the buyer would most certainly initiate a court procedure against the agency in order to protect his rights, which could have a consequence the repayment of the sale and purchase price in the amount of 5.5 million euros in the dinar counter value, plus the appropriate interest, which would be, as a consequence, obligate the budget of the Republic of Serbia to which account the money from the sale capital is transferred. Then the final 2 paragraphs of that page. The factual and legal complexity of this situation, the possible consequences, as well as the need for taking a stand based on interpretation of the privatization regulations, and regulations about contract and torts are precisely the reasons why the agency, in line with its legal and contractual authorizations, was not able to make a decision in this case without previously obtaining an opinion from the Ministry of Economy. In line with this, the decision was made not to take into consideration the case of BD Agro AD Dobanovci before the receipt of the response of the Ministry. That is the conclusion of the government. Mrs. Radović-Janković, it's correct, isn't it, what it says here, that this was a factually and legally complex situation for the agency, and that's the reason the agency never took a decision on the matter.
Činjenica je
It is a fact that these things existed. The unresolved legal issue is a fact because there were two opinions not to terminate the contract. Then we had the opinion that it should be terminated. There were differing points of view. There were a lot of discussions and considerations regarding these matters. So all of the things stated here are true, but the agency had a uniform practice towards all entities undergoing privatization. Therefore, we treated this entity the same as the other ones.
Madam President, I'm going to go to a different topic now, so this might be a good time for the break.
Absolutely. So do you have an estimate how much longer your cross-examination will be?
I will give you a better estimate when I come back from the break. I'll try to shorten it up.
That's usually what happens,
Yeah.
absolutely. And then, yes, no, because we had envisaged possibly to hear Mrs. Vukovic after this witness. Is this still a possibility? It may be premature to decide it now, but just making sure that it's still a possibility.
Yes, yes, of course.
She's
it is
available and
possible.
it's fine on your side as well. Fine, then we can take a 10-minute, 15-minute break now, maybe 15. Let's be generous. And during this time, Ms. Radović, I should ask you not to speak to anyone about the facts of the case, about your evidence, and the easiest way to avoid this is simply not to speak. Of course, you can move around and get something to drink other than the water.
Da, vi? Moram samo da kažem dobar dan, da vidim da li mi glas radi. Dobro, ima dovoljno da se... Ima ovdje izaći. Aha, ne znam.
So we're ready to continue. Ms. Radovic, you're ready to?
Da.
Yes, I am, and I hope I will sound better. I was quiet for a while. It seems to be better to me.
Thank you very much, Madam President. In terms of time, it depends, I think, on some of the answers, and obviously the interpretation is slowing things down a little bit, but I hope to finish before 5, in which case we would be able to start the next witness.
We'll
I think we go till
see
6.
when we get there what time it is and what we want to do. Yeah.
Okay. Thank you, Madam President. Mrs. Radovic-Jankovic, I'd like to turn your attention now to the meeting of the Privatization Agency of the 23rd of April, 2015. You know, I believe that you were a participant in that discussion, correct?
Ako se radi
You're referring to the meeting of the Commission in charge of monitoring the performance, that is the execution of agreements, then yes, it is correct.
This is, I'm going to call up Exhibit CE768, which is a transcript of that discussion. Have you reviewed the transcript and/or audio of the meeting prior to this arbitration hearing?
imala sam prilike da vidim.
Yes, I have reviewed the transcript.
If we could, first of all, look at the cover page. It confirms who the persons were who were present. It includes Vesna Paunović, Sasha Novaković, Slavica Tanasijević, Branka Janković, that would be you, and then two persons who are not members of the commission, including Julijana Vučković, and then Milan Lazić is not present. Could you tell us which members of the commission were appointed by the ministry and which were appointed by the agency?
All members of the Commission. The new law on privatization was in force back then, so all of them are appointed by the ministry. Before that, the Commission was of an internal body, and it included only employees of the privatization agency. So all of the people you mentioned here, including myself, were appointed by the Minister of Economy and Privatization. I can say that all of them were not from the Ministry of Economy and from the agency. Some of them were also from the Ministry of Finance and Ministry of Labor and Employment.
If you can recall, were from the Ministry of Finance and from the Ministry of Labor?
Ja ću sad
I will attempt to recognize the names. Madam Paunović, I believe, came from the Ministry of Economy. Mr. Novaković, possibly from the Ministry of Finance. Slavica Tanasijević from the Privatization Agency, myself from the Privatization Agency. The rest from the agency, they had the position of expert assistants. They were assisting the Commission. And I believe that Mr. Milan actually cannot remember. He could have been from the Ministry of Finance. He could have been also from the Ministry of Labor and Social Issues. It's been many years have passed since I've been there.
If we could look at page 2 at the bottom in the English, and my colleague Sarah is able to locate the citations in the Serbian version for you. So there at the bottom, I believe the speaker is Ms. Vučković. She says, bearing in mind that all other obligations were fulfilled at the time, the Commission took a standpoint to ask for the opinion of the competent ministry, since this was the buyer's only remaining obligation. And I believe if you look in the paragraph above, the this refers to Article 534. Now, if you look at the paragraph above, sorry, the paragraph that starts first of these provisions, 533. It says 533 was prescribed as a basis for termination of the agreement, and the other one, which refers to pledges in accordance with the agreement, and I believe that refers to 534, was not prescribed as a basis for termination of the agreement, although Article 41A of the Law on Privatization, which is applicable on these agreements, prescribes that an agreement may be terminated in case of explicitly listed violations of contractual obligations. And in the last item of the article, it prescribes it may be terminated in other cases as prescribed in the agreement. Do you see that?
Da.
Am I,
Yes. Da li,
sorry, did you understand Ms. Vučković there to be saying that termination under Article 41A of the law on privatization would be based on explicitly listed violations of contractual obligations?
Ja,
I really wouldn't like to go into interpreting the statements of Madam Vučković. You will be given an opportunity to hear her statement, and I prefer myself not to interpret her words, if you agree.
To ask you how you understood what she said at that meeting, if you recall.
Well, I understood it within the meaning of the law. The law enumerates the cases when an agreement may be terminated. There's also a general part of the provision which says, and it can be also terminated in other cases stipulated in the agreement.
She said at the end, but there's a part in there where she says that the law prescribes that an agreement may be terminated in case of explicitly listed violations of contractual obligations. Did you not understand that to mean that under Article 41A, the agreement could be terminated for violations that are listed as violations in the agreement?
According to my opinion, the agreement may be terminated on the basis of provisions of the agreement which are contrary to the imperative provision of the law, regardless of whether they are enumerated under item 7 of the agreement or not.
Okay, I'm going to show you a different quote here. And first I'm going to show you something that Ms. Vučković said, and then I'm going to show you something, or play for you something that's said by someone else at the meeting. On page 4, in the middle of the page, Ms. Vučković says, quote, "If this disposal of shares is permitted, and the buyer is, I repeat, entitled to this in accordance with the agreement, generally the agency would no longer be in contractual relation with someone, and you would no longer be able to take measures against the contracting party." Do you see that?
Da.
And then if
Da,
we go
da.
to page,
Yes.
Ms. Vučković says on page 11, quote, "Well, because so the agreement prescribes that the pledge is deleted once it pays the purchase price and not when it fulfills its obligations." Then someone says, "But the agreement also prescribes that it is prohibited from selling, like selling these, that is," and then she says, "That is right. It violated one of the provisions of the agreement, and the release of the pledge is not tied to the fulfillment of contractual obligations. Rather, it is tied only to the payment of the purchase price, which was clearly done carelessly in the agreement." And now, I'd like to play an audio on the same point. The person on the audio in the transcript is referred to as female voice 2. I'd ask you to listen carefully to the voice because I'm going to ask you to identify, if you can, who the voice is of.
On imati problema, objektivnih problema da izvrši ove naše naloge. To je jedno. I da li u tom kontekstu će on imati problema, objektivnih problema da izvrši ove naše naloge. To je jedno. I drugo, sad odnos ugovora i predloga odluke oko ovih zaloga na akcijama, zato što prema ugovoru praktično zaloga treba da se briše kada isplati cenu koju je on isplatio.
To je moj glas, da, to sam ja govorila.
This is my voice, yes, these are my words.
In the transcript, you are female voice 2, correct?
Jeste.
It is correct.
Let me play you another clip of you. And this is an audio clip, but it is also on page 10 of the English transcript.
A u ugovoru o kupovini kapitala je rečeno da može da raspolaže sa akcijama, jel?
Da može kada isplati prodajnu cenu. To je on i učinio. Ali ako bi mi sad doneli tako, bar po mom mišljenju, ja ne bi bila sklona, mada imam problem sada sa ugovornom obavezom koja je tako. Ako bi ministar skinuli tu žalobu, on bi mogo slobodno da raspolaže akcijama i da se prodaju. Tako da bi se ja sve založila za to da mi odložimo to brisanje zaloge do izvršenja, odnosno do isteka ovog roka dok on ne izvrši ove obveze ugovorne koje smo mu naložili da uradi, odnosno ne nije to. A mi ćemo ih potvrditi kroz našu odluku. Sad jedino ne znam, oni mogu okrenu neki spor i mi kršimo ugovor.
Ms. Radović-Janković, it's a fact that at this meeting you acknowledged that the buyer was entitled to have the pledge deleted contractually, correct?
According to the agreement, according to Addendum 1 of the agreement governing the pledge, the buyer had the right to have the pledge returned to him after 5 years or after the payout of the price. Those are the facts. Practice is something else, however.
In the second clip that we heard, you said that he can dispose of the shares freely once he has paid the purchase price, but then you recommend not deleting the pledge until after the deadline expires, correct?
It is correct. I have made that statement, first of all, because we did not perform our obligation, because Mr. Obradović has not performed his obligation. It's a matter of reciprocity, really, pure reciprocity. Secondly, had we removed the pledge, then the buyer would have been free to dispose of the shares. He could have transferred them to whomever, and he would be able not to perform his contractual obligations, because the provision governing the pledge was formulated. It's related to bona fide buyers. In more than 90% of cases, for sure, the buyer was paying out the price as the final contractual obligation, meaning the buyer had already performed all contractual obligations, and then the buyer would pay out the price. However, the situation here was different. Mr. Obradović had not performed his contractual obligation, but he had paid the price, the purchase price. Therefore, if we were to allow the purchase price its payout to be deemed as the fulfillment of all contractual obligations, which is not possible, we would really ruin the foundations of the entire privatization process. And I believe I've said this before, but let me repeat it. In that case, we would start a new practice regarding the buyers. The rest of the buyers, the other buyers, would consider, once they pay out the price, they fulfilled fully their contractual obligations. We would have to return the pledge to them, and they would be able not to fulfill the rest of the contractual obligations and do whatever they wanted to with the assets.
Jankovic, you did not say any of that at the meeting, correct?
What do you mean I haven't said any of these things at the meeting? I said these things at the meeting.
Well, you did not talk about practice in other cases that would allow you to legally not release the pledge. Correct?
Actually, let me quote, if we were to delete the pledge, he would be able to freely dispose of the shares, and that would constitute an issue for us. I would be in favor of postponing the deletion of the pledge until the performance or until the expiry of the term by which he needs to fulfill his obligations. Maybe I didn't go entirely into details there, but this has been discussed by the agency so many times before.
Page 4, you just, a couple of questions earlier, you mentioned that there was a practice of not releasing the pledge, I believe. Correct me if I misunderstood you. Was there a practice of not releasing the pledge if the buyer had not fulfilled his last contractual obligation?
Yes, there was a practice in the agency, and I said why that practice existed. Because releasing the pledge would render the process of privatization pointless. And I'm repeating here, Mr. Obradović had not met his contractual obligations, and in this case, we did not meet our contractual obligation. That's pure reciprocity.
Now, I cited for you several times where Ms. Vučković stated that, quote, release of the pledge is not tied to the fulfillment of contractual obligations, rather it is tied only to the payment of the purchase price. You did not correct her statement there when she made it during the meeting, correct? You didn't challenge it.
No, I didn't challenge it.
Now, you made a comment, if we could go back to page 10. The last sentence you said there. Sorry, at the top, female voice too, at the top, there. The last sentence starts, now after you suggest that you don't release the pledge and wait for the expiry of the deadline, you say, we have ordered it to fulfill. That is not us, but the minister ordered it, and we will confirm such decision. Now, I just don't know. They can enter into certain dispute, and we are in violation of contractual. Now, it doesn't complete the sentence, but what I understand there to mean is that you are in violation of your contractual obligations under the pledge agreement by not releasing the pledge, correct?
I am not challenging that the agreement said the pledge should be released once the purchase price has been paid, but this implied that the other obligations had been met by the buyer too, which in this case had not been done. And this wasn't the first time that we didn't release a pledge, although the purchase price had been paid.
Not to release the pledge because you felt that he had an obligation to first complete all his contractual obligations, then you wouldn't have said, we are in violation, right?
I was the chair of the commission. This was a completely new commission. Those people were new, and I had to report to them what had been written and how it had been written, but I also hinted at what might happen and what the consequences would be. And I think that Mrs. Vučković says somewhere there what the practice of the agency was. This is why I suggested not to do anything for the time being until a supervision decision was taken.
If I can turn your attention to pages 4 to 5, again in the English. Ms. Vučković mentions, quote, we have mentioned daily communications we are receiving from the employees and trade unions where they are requesting urgent measures to be taken and stating that they generally have big problems concerning business operations, in particular maintaining production and keeping the cattle alive, which is the core business activity of the subject of the privatization. Were you aware that the agency was receiving daily communications from employees and trade unions?
Those messages did not reach me personally because it wasn't in my area of responsibility, but I learned at commission meetings that this entity undergoing privatization had been almost destroyed. Our obligation was to follow a social program during 2 years. We sent all these letters to the competent authorities, the prosecutor's office and the Ministry of Interior, all those letters from the trade unions.
and trade unions had been sending letters for years to the agency about BD Agro, correct? Do you know that?
As I said, I'm not quite familiar with this because it was not my official duty to receive those, except for what I saw at commission meetings. But the agency, when it comes to these complaints about unlawful operations in this entity undergoing privatization, sent this to the competent authorities, and they dealt with it.
Cases where employees of the agency were wrongfully arrested and investigated on the basis of allegations brought by employees, groups, and trade unions.
I do know that certain employees of the privatization agency were arrested, but I don't know if it was based on allegations by groups of employees. I don't think this was connected to this entity undergoing privatization. I think it was different entities.
Your attention to...
I apologize. And here you have the answer why the agency really took a long time to think about each of its decisions, because it was all the time supervised by the prosecutor's office and the police and all the other competent authorities. We had to be conscientious in our decision making, and we had to have uniform practice in dealing with entities undergoing privatization.
Let me turn your attention to Exhibit CE 895. And this is a case where Ms. Vučković was arrested by the prosecutors in a different privatization. Were you aware of this case?
I was aware that Mrs. Vučković was arrested, and of course she was released and there was no indictment. But unfortunately she was in prison and suffered all the moral and other forms of damage that she could have suffered.
Wrongfully accused, right? She was wrongfully suspected, I should say.
Yes, she was wrongfully suspected.
Article, at the paragraph that begins, at that time, the labor union of Azotara employees warned all public authorities, the police, the judiciary, the ministries, the privatization agency, that a state-owned company was being robbed and that part of the factory was being sold without permit. No one reacted then, and the plant was exported. So actions of employees and unions were a frequent occurrence in many privatizations, correct? Protests, allegations, etc.
I do not understand what you want me to answer.
Are you familiar with the fact that employees of the privatization agency were often subjected to false allegations by employee and trade union groups?
Yes, I'm familiar. Those were false allegations.
If we could turn now to a statement issued by the privatization agency on the 25th of April 2012, and this is Exhibit CE 897. This is from the website of the privatization agency, and a release was issued to note that Ms. Vučković had been released from custody. And first of all, have you seen this release before? Did you maybe participate in its drafting as a legal advisor to the director?
No, I don't think I took part in its drafting. I don't really remember. Unfortunately, Juliana Vučković was not the only employee of the agency who was arrested. Many of our colleagues got arrested, so I can't really recall either this text or what it said. These are really difficult things for me, and hard for me to talk about them.
I want to actually follow up on your point that many of your colleagues were arrested. If you could look at the third paragraph of the agency's statement there, it says, "We emphasize that this is not the first time that the agency or its employees, although politically neutral, have been publicly abused and labeled as part of corruption and organized crime in Serbia. It is unacceptable for the employees of the agency to be permanently exposed to malicious public and undocumented commentary of their work and used as media baits in the pre-election campaign aimed at creating a negative image of the privatization process in public." Are you familiar, I guess following up on what you said about many of your colleagues being arrested, were you aware of this climate at the privatization agency at the time you worked there?
The topic of privatization is very interesting for politics, and it was used a lot in politics. But I'm not a politician. I was a professional, and I would not want to comment on this, if you allow me.
Let me go back to the meeting on the 23rd of April. If we could go to page 11 of that document, which again is Exhibit CE 768. Now, this is, again, I started with this earlier. It's Ms. Vučković at the top that says, "This is right. It violated one of the provisions of the agreement, and the release of the pledge is not tied to the fulfillment of contractual obligations. Rather, it is tied only to the payment of the purchase price, which was clearly done carelessly in the agreement." Then she says, "Now, the new law rectifies this somewhat, and it prescribes that the certificate on deletion of the pledge and fulfillment of contractual obligations is issued once all obligations are fulfilled, and not only payment of the purchase price." You see that?
Da, vidim.
And
Yes, I do see it.
what she's saying there is, under the new law, you rectified this situation where now the release on the pledge would only be released after the fulfillment of the final obligation, correct?
Da, no.
Yes, correct. This law corrected it, and it said that the pledge is released once the contractual obligations had been met and not when the purchase price had been paid, which was logical and which was a result of our practice.
That was not the case. That's why an amendment needed to be passed, correct?
But the old law, as far as I remember, did not deal with this issue of pledge. It seems to me that the pledge was only an issue of the agreement. I cannot recollect this precisely. And then the new law included this as a provision. I really cannot remember this now, but it seems to me that the old law did not deal with pledges.
It's fair to say, you would agree with me, that BD Agro's privatization agreement was governed by the old law, not the new law, correct?
Da, on je...
Yes, it was concluded under the old law, and the provisions of the new law said that an agreement was to be terminated in line with the provisions of the old law.
Mislim da...
If we can scroll down now and following up on what we discussed and where you said that many of your colleagues had been arrested, and I believe you also said that you were under the scrutiny of prosecutor's office and other institutions in your work. The conversation continues and it says, and that is it, and we are now between a rock and a hard place, because on the one hand, we have an obligation in accordance with the agreement, and on the other hand, the consequences of this are clear to you. Question, and when did it pay the purchase price? In 2013? Ms. Vučković says no, the 6th installment was paid in April of 2011. Then someone's, that's you say, I don't know how we could not regulate this to cover both things. And then someone says, if we consciously give it to him now, not even God could cleanse us. You understood that the dilemma of why you were between a rock and a hard place, according to Ms. Vučković, was on the one hand you had an obligation, and on the other hand you were under this scrutiny that you referenced earlier in your testimony, right? From labor unions, employee groups, the prosecutor's office, the police, etc.
Da,
Yes, was that a question?
That's what that meant, being between a rock and a hard place, and only God could cleanse.
Nije to baš tako značilo, mislim.
No, that's not what it meant. We took our decisions independently after a lot of analysis from different angles in terms of different consequences, what would happen if, and that's how we established our practice. This practice changed over time with more experience. We adapted our practice to the new conditions. We practically started from scratch. The first privatization in 2001, we don't count the one that had happened many years before, started from scratch. We didn't have experience, we didn't have any rules, nothing existed, and we built it step by step.
Ms. Radović, I want to take you to what happened immediately after this meeting, and that is Exhibit CE 348. This is, if you look at the heading, letter dated April 28, 2015, from the Privatization Agency to Mr. Obradović, and if you look at the signature page on page 3,
Dobro,
that's your document.
moj, jeste.
Did you prepare it?
Ne, ja prvo bi morala da vidim šta...
I would need to check the document first. I can't recognize this. In principle, I don't believe I was the one who drafted it. It may have been drafted by other employees, people who were experts in this, and I had the authority to sign the document. Of course, before signing a document, I normally read and analyze the document.
Okay. If you look at the document, again, which is one you signed on page 2, the top, if we go, scroll to the top, please, of page 2, sorry. Now, first it references a notification on subsequently granted time of November 9, 2012. Do you see that?
Dobro. Dobro.
So this was the first notice of subsequently granted time requesting compliance since November 9, 2012, correct?
Da.
Yes, correct.
So almost 2.5 years passed between the time the agency issued one notice and extension of time, and then this one. Can you tell the tribunal why it took 2.5 years for the agency to issue a new notice?
As you can see, in 2012, the last deadline was set for Mr. Obradović, and he had not fulfilled his obligations. In 2013, the Ministry of Economy started supervising the privatization agency, and this decision on the results of supervision was received by us in 2015. And that is why this letter was made then, after supervision had been conducted. However, in the meantime, there had been different events. As you could see, there were many documents, huge documentation that was produced by the agency in this time. So we did not just sit and wait, we worked.
Your letter, could you please explain, or let me first say, it says the buyer needs to do the following: fulfill the obligation from Articles 533 and 534 of the agreement. Right, that was the one that was contained in the notice of. Sorry, fulfill the obligations contained in Article 533 and 534 of the agreement, and submit evidence that all payments from the sale of fixed assets have been received and used for the needs of the subject, all burdens have been removed, and all other security instruments for third parties have been returned. All burdens registered on no grounds have been removed, and all loans have been returned that were given by the subject to third parties from credit resources secured by burdens on the subject's assets. Do you see that? You were writing to Mr. Obradović saying that all of those things needed to be done in order to be in compliance, correct?
Da.
Yes, I can see that. I signed this as the president of the commission. This was the conclusion of the commission following the meeting held on the 23rd of April 2015.
Now, if we go to the next meeting of the commission, which was on 19 June 2015, and this is Exhibit CE 770. If we go to page 6, it says, personally, I think that the disposal, this is not referencing 533, personally, I think that the disposal was not in excess because it was a case of force majeure. What will be our final, or rather the commission's final position? I may have prejudiced it a bit at this moment and presented my opinion, but it really is not logical to me for us to impose obligations on anyone or terminate the agreement for disposing of assets in excess, and in reality, it was force majeure. Do you see that?
Da.
Okay.
Yes, I can see that.
4 days after this, discussion. Mr. Obradović received another notice, and if we could take a look at that, CE 351. Again, this is a letter to Mr. Obradović from the Privatization Agency, and I'd ask you to look again at the signature page. Is that your document?
Yes, sir.
Yes, it is.
It's a short document. Can you tell us whether you prepared it?
No, I'm not the one who drafted documents. The same goes for the previous one. I signed it as the president of the commission. The expert assistants normally drafted documents, and they would draft documents based on the conclusions of the commission.
If we go to the second page, number 7, it says what Mr. Obradović has to do by July 27. And the first point is provide unequivocal statement on the performance of the obligations of the buyer referred to in Article 533 of the agreement, concluding with April 8, 2011. Can you explain why the Commission was insisting on 533, even though in your discussions you all were aware that it was a result of force majeure?
Yes, we did say so, and I presented this as my opinion. I share it with the Commission members. However, we must have the auditor's report. It's the auditor who needs to say that this threshold had not been exceeded, even if it was the case of force majeure, and all our reports were based on auditors' reports. I can't tell you much about it because I never received those auditors' reports. I would normally receive parts of auditors' reports that were presented as material for the Commission meetings, but I'm sure Ms. Vučković can tell you more about it. This simply was not the area of my work.
Bullet point there of what Mr. Obradović was being asked to do. Again, provide a statement on performance of obligations referred to in 534 and confirm that all encumbrances were deleted and all other security instruments for the obligations of the third persons were returned. Burdens registered without basis were deleted, as well as that all loans given by the subject to third persons from the loan assets secured by encumbrances on the property of the subject are returned. Correct?
No.
Yes.
And that meant all of those things had to be done in order to be in compliance with the agreement from the Commission, from the agency's perspective, correct?
Yes, of course. He had to remove all pledges that he had placed for the benefit of third parties on the assets, actually for the needs of third parties, because the agreement was saying that he could place burdens on the company's assets for the needs of the company only and for the needs of company's regular operation. He could burden his own assets, but before that, he needed to obtain the approval of the privatization agency. This is what the agreement said, and Mr. Obradović never required such a consent or approval.
Madam President, may I just have a moment to consult with my colleagues?
Sure.
Thank you. Ms. Janković, thank you very much for your time in answering my questions. Madam President, that concludes our cross-examination.
Thank you. Hvala vama.
Thank you.
Questions in redirect?
No, Madam President, thank you.
Fine. Do my colleagues have questions for Mrs. Rodovich? Yes, please go ahead.
Good afternoon. Ms. Vučković was not a member of the Commission, as I understand. She was invited to the Commission meeting, is that correct?
Ms. Vučković was the director of the Center for Control of the Performance of Obligations, and she had to attend all commissions ex officio, and she was the reporter to the commission members.
But is she, on the Commission, is she considered subordinate to you, equal to you, superior to you, or is there no such hierarchy?
No, there was no hierarchy there. She was someone who had to report. She did not have the voting right with respect to the Commission decisions, but she was there to give us all the information on a specific case that we were working on.
Thank you, that's helpful. If we could go to your witness statement, please. At paragraph 11. You talk about receiving an opinion from a law office, and then you said at the end, we concluded such an opinion in its key parts was not in accordance with the then applicable law on privatization. What did you mean by that statement?
I think I have already explained, so let me repeat. It's because the law on privatization as the reason for termination stipulated the disposal of assets or property of the company, whereas in the opinion of the law firm, they looked at the article of the agreement which discussed the disposition of the assets, and they did not apply the imperative provisions of the law. In other words, in this opinion of the law firm did not pay attention to the explicit provision of the law which prohibits disposition of company's property. Was this clear enough, or do I need to clarify? The law has supremacy over an agreement, and that is why we always stick to the law for issues that were different than what was happening in practice.
Yes, and on that, I understood from your exchange with counsel that the law on privatization changed to take care of potential mismatch between the pledge and the obligations, so that now obligations and pledge only lift simultaneously. And you had said that prior to that change in law, there was a practice to, in essence, as I understood it, to accomplish the same thing. How do you see that practice before the change in law? How do you see that practice with how did it marry with the law in force at that time, before the change in law?
The privatization agency, if the buyer would pay out the full purchase and sale price, but has not met with all contractual obligations, would normally not return the pledge. Actually, we had never had problems with that. Buyers never requested the return of the purchase price until they fulfilled all the contractual obligations. In this case, we had a situation where the price had been paid out, but contractual obligations had not been fulfilled that had been imposed much before the contract, that had existed much before. So the buyer can freely dispose of company shares. They can transfer shares onto a third party. They can sell the entire assets of the company. So the actual purpose of the privatization would not be met. And I repeated this a number of times here. And the whole privatization process would be devalued, and then other buyers would be paying the sale price and not meet other contractual obligations. And the law has this provision which says up until the full sale and purchase price is paid. So buyers in reality could say, okay, I have paid the purchase price, I have the certificate that I have the pledge returned, and now I can do whatever I want with the assets. This was a bad provision, and we tried to correct this in practice. But then the new legislation enacted in 2014, this was rectified, and the new law was saying that the pledge can be returned only after all contractual obligations had been met, and not when or after the purchase price had been paid out. Paying the purchase price is just one of the obligations. All the obligations need to be fulfilled cumulatively for an agreement to be considered fully implemented.
I understand that it is possible, or it was possible, for the privatization agency to approve an act of the company that, but for the approval, would be a breach of 5.3.4. So, in other words, I understand it would have been possible for the company to approach the agency and say, I'd like to take a loan and it may breach 5.3.4, but I would like your approval to do it anyway, and it's possible for the privatization agency to approve it. Is that correct?
Yes, it is correct that the assets could have been encumbered by either a pledge or a guarantee in favor of third parties. It was only prohibited for third parties in cases where consent was received from the privatization agency. In such cases, the agency would analyze the condition of the company, whether it was justified to allow such encumbrance in favor of a third party or not. But in this case, such consent from the agency was not even asked. Almost the entire assets of the entity undergoing privatization were encumbered. And the loan which was taken for the needs of third parties was not repaid even, well, I don't think it was ever repaid. The money wasn't repaid, the mortgage wasn't deleted, and that is stated as such in the last auditor's report.
I had understood one of your answers to be that the breach, or the alleged breach, could have been rectified by repayment of the sums by the two third-party companies back to BD Agro. Do you remember that answer?
Yes, had the funds that were given to third parties been returned to the entity undergoing privatization, it would have been deemed as a fulfilled obligation. Had the funds been returned, the mortgage would be deleted and the contractual obligations would have been deemed fulfilled. So it would have sufficed for the funds given to third parties in breach of the agreement and the law to be repaid. The agreement would have been deemed fulfilled then.
My understanding would be that the money would have been paid back, let's say, on day one. The pledge would have been lifted on day 2, and the privatization agency would have said to BD Agro, yes, you fulfilled your obligations on day 2, and then on day 3, BD Agro would be a private company and then could return the money back to those 2 companies freely. Is that correct? And I don't mean day 1, day 2, day 3 literally, but those 3 steps could have taken place.
Pa dobro, to ne bi...
Yes, exactly. It wouldn't be day 1, day 2, day 3. The removal of the mortgage would take some time. But yes, it would ultimately be deemed as fulfillment of contractual obligations. Once they fulfill the contractual obligations, it's a private company. They can do whatever they want to.
So, good afternoon, Ms. Radovic-Jankovic. I would like to come back to...
Good afternoon.
I would like to come back to the changes in the privatization law. You mentioned that the new law was adopted in 2014. In law in general, there is a distinction between immediate effect of new rules and retrospective or retroactive effect of these new rules. Could I ask any party to put on the screen the 2014 privatization law? It is CE 223. Is it in the folder, in the bundle for the cross-exam? No, but maybe it can be put on the screen. I would like to show Article 15. Probably we can put it in Serbian language first for the witness. Article 15. It is in the English version, there is Article 15 and in bracket S1. I don't know whether this is a difference or not. And I don't know whether this is the right... have you read it?
Da, da, da.
Okay.
Da.
Yes, I have.
Could you please put the English version? It's 15. Going up, please. Well, what I mean is Article 15 in bracket S1.
I think it's not the right document that you're citing to, so I'm not sure.
I asked for the law of privatization 2014. Article 15 S1. I have it in front of me, and it is CE 223. Article 15 in brackets S1.
We have exhibit
If I may, Professor Cohen, if I may, this is the end of the document. So just scroll down. This is the... Yeah.
Okay.
Transitory provisions. Yeah.
Could you please put this in Serbian for the witness? And now in the English version for all of us. Okay, thank you. So So privatization procedures initiated prior to the day this law entered into force shall continue according to the provisions of this law. Any comment about this? Do you consider that this article would be applicable to the case of the privatization agreement of Mr. Obradovic?
I believe that this refers specifically to entities undergoing privatization at that moment. In case of Mr. Obradovic, we were discussing a termination of his agreement, and there's a provision of the law included here in the transitional and final provisions, which actually says that agreements concluded before the entry into force of this law would be terminated in line with the law which was valid once those agreements were concluded, meaning in line with the law from 2005. This article relates only to ongoing privatizations. This law was aimed at introducing some, let's say, relaxation into the privatization procedure, because we wanted to finalize some privatization processes, because some of them took much longer than was initially expected. I hope my answer was clear. I believe, therefore, that this provision does not have a retroactive effect. I believe it is only applicable to procedures which were ongoing.
Hvala vam.
So I believe that it refers solely to the procedures which were ongoing, which were not finalized, and I believe it's not retroactive. As regards specifically cases of termination of agreements, regulations which were in force once those laws were adopted were still in force. If we were to say that this law would be applicable, it would be retroactive, because in 2005 they would not be able to know what would be applicable to termination of the agreement in 2014. So this law is not applicable to termination of agreements which were concluded in 2005.
Your answer was clear.
Thank you.
My second question concerns the privatization agreement between the privatization agency and Mr. Obradovic. Could I also ask one of the parties to put the privatization agreement on screen? I refer to Article 9, which is the dispute resolution clause. I suppose the witness has the Serbian version? Okay. Yeah, take your time to read it, please. And tell me when it is fine. Okay. So this provision explicitly excludes item 7, that is to say the termination, from the dispute resolution manner envisaged here in item 9. My question is, which kind of remedies had the seller in case the privatization agency decides to terminate an agreement? Which kind of remedies are available for the seller in the case of a decision of the privatization agency to terminate the agreement? If the other party of the agreement doesn't agree. So
Well, in that situation, there's always a court dispute. Always, if the other party disagrees. We've had quite a few of court proceedings. So the only remedy, the only instance court level is that you cannot complain to the ministry, but you can initiate, you can conduct a dispute. I see that this provision is a bit, I'm not sure if it was formulated in the best way, but yes, disputes are conducted, and we have quite a few when it comes to privatization cases.
Court would have jurisdiction in this case. That was my...
It would be the commercial court. I believe it is the jurisdiction of the commercial court.
Be exactly the same of item 9.
Well, I truly cannot think of any other court which could have jurisdiction. I'm not sure if I'm able to answer to you how come cases under item 7 are excluded. To be specific in this case, we don't have item 7, we have item 543. I know from my experience and practice from the privatization agency that all of these disputes are mostly conducted before the commercial court.
Thank you. Were there many cases of termination of privatization agreement during your term in office?
I do not know the exact figure now. I might have known it in the past, but truly at this point in my life, I do not have a figure to share with you. But what I can share with you is that most of those disputes were decided by the court in favor of our agency. I hope the answer is clear. I'm not sure it suffices as the answer to your question, but that is what I can answer.
For a specific figure, but I wanted to know more or less how many.
Well, yes, there were such disputes. I cannot remember exactly the figure, but the agency was always aiming at avoiding termination of agreements. We were really trying to even interpret the law in a way which will allow us to avoid terminating the agreement. Even when it comes to this case, we try to do that. And in most cases, we won the court proceedings. Of course, there were some which we lost as well, but the figure was much lower.
The cases in which the agency lost, how was the situation afterwards? How was the dispute arranged?
Well, in such cases, regarding the giving back the company, etc., the law says it cannot be done. The shares would be transferred to the shareholding fund, later to the privatization agency. The employees were the only ones that were allowed to keep their shares in such cases, and the state had to pay out the purchase price plus interests until the day when the decision became final.
Questions?
Just to follow up, if I'm not mistaken, you told us in the course of your examination that you were dealing with about 4,000 companies. Do I remember this well?
Yes, I did say that, though I must say now, it's very possible that there were more than 4,000, very possibly 4,500, but I'm not sure about the figure.
So among those 4 or 4,500 companies that were privatized, can you give us an idea of how many got their privatization agreement terminated? 10, 400, 1,000? Just a general idea. Is this something very frequent? Is it something very rare? Is it in between?
I would say it was moderately common. I really forgot the specific data. However, it would also happen that the agreement would not be terminated, everything would be fine, all of the obligations would be fulfilled, and then it got sold to another entity, and the new entity, the new buyer, would destroy the company, and the company would no longer exist. There would be such cases as well. I don't want to guess on the figures because I might truly make a big mistake. We had all analysis of such things at our disposal, but I've been retired for 6 years now. Many things have changed in the meanwhile. If this means something to you, I could try to get these data and provide them to the court later, but not now exactly.
Speaking of the time when you were not involved, I understand you retired in 2016, and I was just asking for the time before. I suppose when your decisions were challenged, this was something one would remember, no? And especially if you lost later the court case, but even if you won them, you would remember as well.
Well, it's a very difficult question, truly. What I remember is if our funds are frozen, because we had to do a payout to the buyer once we would lose a dispute. That's what I remember. That's what strikes me the most. But let's say that it could have been in 20% of cases. I would presume it wasn't more than that, but please do not take this as a firm figure.
Indication, no. I take it as such, and I understand your reservations. When you discussed the practice of the privatization agency not to release the share pledge when not all contractual obligations were met, even though the payment of the price may have been fulfilled, you said that this practice existed because otherwise the privatization process would be pointless. And you say that you said during your examination today, but you also said it in writing at the end of paragraph 17 of your witness statement, if you want to look at it. But essentially, I understand it's, you say there the same thing. You say if you were to release the share, this would set a precedent, and other buyers as well may pay the sale and purchase price and not fulfill other obligation, which would render the purpose of the privatization senseless. Yes. Why are you saying this? I mean, the company would have become a private company, and in that sense, the privatization would have been achieved. Maybe some obligations that went with it were not completed, but I'm just not sure why you make this categorical statement.
Well, because the privatization process did not have at its aim only to turn socially owned capital into private capital. There were also the principles of privatization which were enshrined in the basic provisions of the law, and that's economic development, social stability, technological development. etc. And when we set investment obligations for buyers, we ask for that in order for the company to develop and in order for it to have a promising future. If the agreement were to be terminated with the payment of the purchase price at the very beginning, then it could be transferred to another person, a third person, who no longer would have the obligation to make an investment or keep the employees.
You're saying with respect to the investment obligations, here they had been fulfilled, if I'm not mistaken. And if I am, counsel will correct me. But I'm asking myself whether the position the privatization agency took here were not directly contrary to what you're now saying about ensuring that the company has a promising future.
Well, I do not think it was contrary to it, because when it came to that, when the agreement was to be terminated, there was almost nothing left of the company. The assets had been sold or encumbered, wages were not being paid, the enterprise had been destroyed completely already. And this was a big agricultural holding that unfortunately ended like that. And we are all really, really sorry because of that. And this is why we wanted to be forthcoming with Mr. Obradovic. Of course, in other cases of privatization, we granted additional deadlines, many deadlines, in order to keep the agreements in force.
Of course, one could object to what you're saying. I'm not saying I do it, but one could object that there was a reorganization plan in place, was approval of the creditors, and this could have gone forward and gave a chance to the company, and the alternative was bankruptcy. So what was better if you think of the future of the company, if you think of protecting jobs?
But
yes, but as far as I remember, the problem was that in order for somebody to take over the agreement, he needs to meet certain obligations, and a buyer needs to meet certain obligations. In order for the buyer to have the agreement assigned, he had to give a guarantee. At that time, the guarantee was a mortgage in the value of 30% of the price that he had paid. And Mr. Obradovic said that he couldn't do this. As for the buyer, not buyer, that is the assignee, those who would receive the company, they didn't meet certain obligations either. They sent some documentation which was never complete. So further, I don't know why they did not submit the documents that had been asked. There shouldn't have been a problem to send those documents. We had many assignments of agreements. It wasn't the first assignment of an agreement that we would have done. But simply there was no will, and it seemed to me that the assignee didn't want to take over the obligations of the buyer, and they would have had to take over the obligations of the buyer. So,
why are you saying that assignee didn't want to take over the obligations of the buyer?
But na tim sastanku.
Well, at those meetings, those two meetings that I attended, I remember that they said didn't want to take over those obligations, the obligations that the buyer had not met during the implementation of the agreement.
We'll assess this as we go forward, and I thank you very much, Mrs. Radovic, for your assistance. I assume there are no clarification. There was one, it's a clarification?
Yes, of course
Because
it is.
obviously there's lots
Of
that
course,
could be said about the
Yes, of course.
last answers, and we will of course
Yes. Of course it is.
look at the record and look at the other evidence. Goes without
One
saying.
question, and it concerns clarification. Ms. Radovic, could you please tell us whether the law on privatization, before it was changed in 2014, I think, regulated pledge on the shares at all?
Mislila sam da toliko...
I thought that I knew that law so well, and I had participated in its drafting, but really, now I cannot remember that. It seems to me that there is a provision on pledges, but I really cannot remember what kind of provision.
Žao mi je.
Thank you, Madam President. I have no further questions.
Fine. Thank you very much,
Hvala
Ms.
vama.
Radovic, for your help. So it is now 5:20. I think it's a little late to start with Mrs. Vukovic because I don't know what the estimate is. Maybe you gave it to us yesterday, but it will not be a very short examination, I assume.
Yes, it will be, I would say, roughly as long as this one.
Yeah,
maybe a
that's
little
what I
shorter.
figure out. Yeah, so it's better to do it tomorrow, and it is not an issue because we're well on time. So we will continue according to the schedule, which means that tomorrow we will hear Mrs. Vukovic, then Mr. Setkovic, and then Mr. Stevanovic, and that will end the fact witnesses, and the day after we'll start with the experts. Is that the plan?
Yes, that is the plan.
Good. Is
We
there
confirm,
any? I see that you're in agreement, so that's always very nice. Is there anything that we need to say before we close for the day? No? No.
Nothing from our side, Madam President.
Nothing from respondent side. Thank you.
Thank you. Then everyone have a good evening, and we'll see each other tomorrow at 9 o'clock.